All right, I think we are ready. It is February 23rd at a little after 1 o'clock. This is the House Judiciary Committee. We have a large number of bills that we're going to be hearing today, beginning with Delegate Valentine's bill, House Bill 682. Do you have anybody else you want to? No, you don't. Okay, then this is Delegate Valentine's, I think, first actual bill. All right, that's fine.
No pressure whatsoever.
No pressure. For 3 minutes, please.
Good afternoon, and thank you, Chair Clippinger, members of the House Judiciary Committee. For the record, Delegate William Valentine, District 2A, representing both Washington and Frederick counties. I'm here today before the Judiciary Committee to present House Bill 682, Public Safety Law Enforcement Agencies Positive Community Feedback. This bill will require law enforcement agencies to maintain a record of positive community feedback for all law enforcement officers within their respective agencies. This bill directs the Maryland Police Training and Standards Commission to develop a uniform process for collecting this feedback from members of the public. These records would be subject to public inspection in accordance with the Maryland Public Information Act. In recent years, the Maryland General Assembly and this body has spent a significant amount of time and effort making changes to Maryland law so that the public could be more informed about the personnel records of law enforcement officers. I believe this bill is consistent with those efforts. This bill contains provisions that would create an accessible and a uniform process that can be implemented by all law enforcement in Maryland. While it is possible for law enforcement agencies to do this on their own, this bill would ensure that all agencies in Maryland have this information on file and available if requested by a member of the public. A uniform standard would make it easier for these agencies to implement this initiative and create a very transparent process for the public. Allowing positive feedback about an officer to be collected, reviewed, and released would provide a more complete picture of an officer's employment history, prior conduct, and patterns. In law enforcement, an officer's future depends on his or her reputation. This bill would help provide a more comprehensive picture of an officer's overall work product. And these public safety professionals are the men and women that protect our families, our communities, and our businesses. Assuring law enforcement that their full record would be available if their reputation or their integrity is questioned or challenged will be beneficial in the continued recruitment and retention of qualified personnel and the future of policing in our local communities and throughout Maryland. This bill is cross-filed with Senate Bill 69, and it received a favorable Judicial Proceedings Committee report on February the 9th of this year and passed a third reading in the Senate on February 17th. I would respectfully request a favorable report on House Bill 682.
Are there questions? Delegate Kaufman.
Congratulations on your first bill, my friend. I wanted to just ask you a question based on the ACLU's opposition to this bill and give you a chance to respond. It says in their letter of opposition, "We believe this bill to be a cosmetic endeavor on the part of law enforcement proponents and not at all necessary for the purposes of police reform." So can you tell me why they're wrong and this goes beyond, in your view, beyond a cosmetic endeavor, as they call it?
Well, I've reviewed their letter, and I have a couple of highlights, or a couple of points highlighted where they talk about greater transparency, and I believe in my testimony I talk about the transparency. And when they talk about patterns of behavior of officers, I think this bill kind of shows an overall more comprehensive pattern where without this, you may only know about bad acts or conduct, where this gives you a better overall view or understanding of an officer. So in other words, if you have an officer and you do an inquiry into his record and all you see are bad acts, whether it be over a 1-year period or a 10-year period, one would assume that that's all that's committed by this officer. This would give you an overall and a better picture of an overall of that officer's personnel history.
Okay. Well, I thank you. And I certainly understand that the need to create a comprehensive picture of an officer. Thank you, my friend.
Thank you, Mr. Chair. I just want to thank you for bringing this bill. I think it's really refreshing. I'm a little confused frankly, by the ACLU's opposition to it. Disturbed, I think, would be a better word. Don't you think the public has a right to know officers getting accommodations? I feel like that's something that the public has a right to have access to.
If they request it, absolutely.
Yeah.
I know many agencies already are doing this, but because it is a personnel record, and I know from past experience in my agency before I retired, if we did receive feedback and it was directly, you would respond back to the individual submitting it, that this would become a record in their personnel file. I wrote those letters, so I know that's how it is, so then it becomes protected. So you would never know as a member of the public the good deeds officers do.
Yeah, that's great. Well, thanks for the bill. I appreciate it.
Delegate Tomlinson and Connolly.
Thank you, Chairman. Kind of piggybacking off what she just said next to me, Delegate Erickson. The bill, yes, the ACLU said the bill is not the result of calls from community across Maryland, but instead a push to give officers a pat on the back for otherwise performing their sworn duties. I can't imagine that's what the bill is supposed to do, just a pat on the back. But as far as like examples, I mean, like what kind of things are you trying to, do you think that would be logged here? Like, for instance, my sheriff up in Carroll County, he was awarded the Governor's Citation of Valor back in 1998 after he shot the gun out of a suicidal man's hand, ending a 2-hour standoff. Is that the kind of example of like that that would be logged in here, or?
I mean, that would be a matter of, that would be an award ceremony, and that's something that would be open to the public. I'm looking at individuals that receive letters, say, for example, an officer or detective did something for you or your family that you thought was exemplary, and you actually took the time to write a letter or an email and submit it. And so, and I know the paragraph you're talking about because I highlighted it on my part as well. We're not soliciting. This bill is not intended to solicit community feedback. This is things that are occurring already and happen every day. It's just opening up to the public should they inquire about it.
Gotcha.
It by no means is a solicitation.
Thank you.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this bill. In reference to the letters that might be written, are they going to be anonymous on the, I guess, on the internet? But they say it's going to be a positive report, or it's going to have the person's name and address? How would that?
It's interesting you say that because I know in normal distribution, or when we literally police departments, when they send out freedom of information, certain things are redacted. So it could very easily be a situation where if you've written specifically about an officer, but you do not want your name and your home address or anything, that would just simply be redacted by the police department. It does not spell out that in this bill, but I'm certainly sure that's something that we could accommodate so that individuals' personal information that provided the feedback would not be then released to the public.
Okay, on the other side of the coin, what about people who don't have positive feedback, have negative feedback? Will they be able to send a letter?
That would be already covered under the prior legislation. That our personnel files are opened for that as well.
So if a person sends in a letter with negative information, then they would have, the public would have to go and get your personnel record to see how many letters you had, complaints against you.
I'm trying to think the process, and that has changed over the years since the legislation a few years ago, at what point that then becomes releasable. But I know that is, personnel files are already opened, so I would imagine that would be covered in that as well.
Okay, thank you very much.
Any further questions for the delegate? Oh, I'm sorry, Delegate Young, thank you.
Now, my question was actually the second question that Delegate Conway had, so I want to just press on that. And I just want to thank you, Mr. Chair. And thank you, Delegate Valentine, for the bill. I think it's really interesting what you're trying to do here. I do question if I wrote a letter, sort of a complaint. Obviously, a complaint would be, you could get it in the MPIA, but a letter, I don't know. And so my only question would be, like he just said, if it was just any letter that go, would you be open to just community feedback and that be the standard as opposed to just positive? So if folks are short of a complaint but want to write a letter, maybe it doesn't rise to needing a complaint. Could all of that just be part of this feedback mechanism, and that would be available as well, just in general?
I would certainly look into that and see if that would be something that would be agreeable. Yes.
All right. Thank you, Delegate.
Are there further questions? Seeing none, thank you very much. That concludes the testimony for House Bill 682. All right. Okay. Delegate Buckle, please. He has House Bill 736. We're going to hear from Delegate Buckle, and then there are two people testifying virtually, only one so far, who will testify against the bill after this. So we'll hear from him for 3 minutes and go from there. All right, Delegate Buckle, go ahead.
Thank you, Mr. Chairman. It seems like a light, fun day here today in Judiciary. I appreciate that. I was here before you. This is House Bill 736. I was here before you about a week ago with a bill that is so simple. I'm a little bit disappointed you haven't already passed it, just throwing that out there. This bill is obviously not in the same genre. But this is a serious, honest effort. I know that the Office of Public Defender will submit testimony that they believe it's unconstitutional for our legislature to try to restrict the conditions of bail. But one thing I think that we all should be able to agree on, and that should not be a partisan issue in any way, shape, or form, is that serious, violent, repeat criminal offenders are a massive problem in our society, and we need to deal with them in a more concrete and more focused fashion. These are the people who are plaguing not simply our urban areas, but many of our suburban areas, and frankly, even some of our rural areas and exurban areas, like parts of the state where I live. What the bill essentially would do, these provisions, I won't say to a T, but largely district court commissioners, I know many of you serving on this committee and many of you are attorneys, you're somewhat familiar with the process. But typically, when someone is arrested and they have an opportunity to seek pretrial release, they first appear before a district court commissioner, who is not a judge, per se, that's gone through the judicial process, and in many cases is not an attorney. That district court commissioner is already generally prohibited from releasing some of the types of people that we're talking about in the bill, repeat violent career offenders, or someone who was charged 2 or 3 months ago, like the individual who shot that poor woman at the Graduate Hotel and killed her, a place where we all go to every year, about a year and a half ago. He had already been charged multiple times within a year for crimes of violence, had been released every time, was back on the streets, supposed to be wearing a bracelet around his ankle, took the bracelet off, continued his nefarious crimes, shot at someone else, the bullet went over a fence and went through the back of a woman's head who was here to celebrate her son joining the Naval Academy. That person should not have been on the streets. They should not have been on the streets. They had already gone through this process. They were already being charged with things. They should have been in jail awaiting trial. And that's simply what the intent of the bill is. I do think that there can be some language modified and amended to it, and I'd certainly be happy with that in ways to try to ameliorate concerns of some of the adverse advocates. But I hope that all of us take this problem very, very seriously. We don't have 50,000 violent career criminals running the streets of Maryland causing harm. We have a smaller subset of these people, but we keep letting them out over and over and over and over again, and they're killing and hurting people in our communities. And we should be serious as legislators about doing everything we can to put those types of folks in jail and keep them there while their cases are being adjudicated. Thank you, Mr. Vice Chair.
Delegate Kaufman.
Yes, Delegate Bucko, it's good to see you.
Good to see you too, my friend.
As you predicted, I do have a couple of questions.
You always have good questions.
Well, thank you. The first thing is, you talked about bipartisanship, and I appreciate that. But I noticed, my first question is, but I noticed the sponsors are all members of your caucus. So did you attempt to get a Democratic co-sponsor for the legislation?
I believe that we did, Delegate Kaufman. I can't tell you, I think it might have been circulated, how we all circulate things through the email system. But I'll be honest with you, I have way too many bills this year for reasons unrelated to this bill, so I can't tell you that I personally went out and solicited the co-sponsors for the bill.
And my second question is, this applies to somebody who has been charged with a certain crime, not just, not always somebody who's been convicted. It says pending charges. Is that right?
So there would be the situation that I just described with the individual that happened here in Annapolis. I am charged with a crime of violence. I am released. So maybe it's my first charge, maybe it's not. I'm released on pretrial release. While I'm on pretrial release, I get arrested and charged again with a second crime of violence. At that point in time, even though the charges exist, maybe you will be exonerated or found innocent, there has to be a consequence for that to suggest that maybe that person should continue to be held, because we let them out the first time on pretrial release, and whether it was a week later, a month later, sometimes the courts, particularly during COVID, were so backed up, it might have been a year later, they committed or at least charged with another crime of violence. So you're right in the sense that it's not solely predicated upon convictions, but it's someone essentially who's getting 2, 3, maybe more bites at the apple of getting charged over and over and over again while they're on pretrial release. One of the conditions, obviously, if you're on pretrial release, you're not supposed to commit any other crimes. And so what happens in the real world as well is people get credit. I don't want people to think that we're letting people languish in jails for weeks, months, years, and then it doesn't go as a credit. The vast majority of times, if an individual pleads guilty, they get credit for what's called time served. So those days that they're being held under the bail provisions count toward their ultimate sentence. And sometimes individuals are released that day. They plead guilty, and the deal that has been worked out is that you're going to be sentenced to, a year, and you've already served a year, so you basically leave prison or leave the local detention center on that date.
Okay, lastly, Mr. Vice Chair, I appreciate that, and you're an attorney and not me, and I think you're even a defense attorney during the interim. But
I don't actually do any criminal defense, or hardly any.
But
I would represent you if you got a speeding ticket.
Well,
that would be about it.
I appreciate that for sure. Just tell me how, I understand where you're headed, and I appreciate the intent of the legislation, but tell me how this provision about somebody with pending charges doesn't violate the principle of innocent till proven guilty.
Well, I don't think that it violates the principle of innocent until proven guilty, because there is no presumption of guilt that attaches to your actual adjudication simply because of the fact that you're continuing to be held. A judicial officer could do this today. What we're saying is the judicial officer shall do it. Many judges, I think you would find across the state, will already do this within their discretion. Some will not. Many judges, they have the ability today to say, hey, I let you out 3 months ago on pretrial release. You came back to my courtroom charged with another similar crime. I'm not letting you out this time. You're staying in with no bail. So this already can happen. Mm-hmm. What I'm suggesting to you is, as a legislature, as a policy-making body, we need to make it more clear to our judicial colleagues, to our co-equal branch of government, that we need it to happen, not just sometimes, but all the time. So it already occurs without negatively influencing the defendant's right to have a presumption of innocence.
Has the Judicial Conference come out in favor of this?
I believe that they're against it, and I'm sure, as you all will find, I serve in a committee where we have the Maryland Association of Boards of Education that appear in front of us every day. Their advocate, we affectionately call him Dr. No, because he is literally against everything that would allow the legislature to have any influence whatsoever of what the Boards of Education do, other than give them money. I think you'll find here the Maryland Judiciary Conference, whom I love. I appear in front of these people. If you're watching this tape, Chief Judge anywhere, I'm very in favor of the judiciary. But at the end of the day, they do not want the legislature, it doesn't matter, my bill, your bill, anyone's bill, telling them how to do anything. And that's their prerogative.
Yeah, I get it. Thank you, Mr. Vice Chair. Thank you, Delegate Buckle.
Thank you, Delegate.
All right, Delegate Young.
Thank you, Mr. Vice Chair. So I'm just reading the fiscal note, and Delegate Buckle, thank you for coming to the judiciary
Thank you.
today. It outlines where the district court commissioner cannot release folks who have been charged.
Right.
But you're now saying that the judge at bail can't do the same thing, correct?
That's what we're looking to do. The district court commissioners are already pretty strictly restricted to this.
Right.
But judges oftentimes, and I can't explain the rationale, but we obviously are seeing these situations again and again where repeat violent career offenders, even while being charged multiple times in a cycle, are being let loose on the streets. And we have to do something to combat that.
Yes, sir. And thank you to Delegate Kaufman for kind of asking a lot of the questions I was going to ask regarding innocence until proven guilty. But specifically, I just question why we want to remove the discretion. You referenced the example in Annapolis, and based on my understanding, and I don't know the specifics other than what you've shared, but based on what you've shared, I heard that it was an individual's potentially first charge. Is that correct?
No, I believe that the history of the individual is he had multiple prior convictions for crimes of violence. He was back. He had served his term of incarceration and was back. He was charged with, I believe, one crime of violence and another crime that would not have been a crime of violence. Was on pretrial release. He was already a prior convicted individual. He was charged with a separate set of circumstances that happened months earlier to the fatal shooting. He was on pretrial release and shot and killed someone else.
I question, I think, though, ultimately the concern about the charges, and, you know, you referenced career criminal. I think that I question whether if an individual is currently charged and it's their first charge or even a second charge and they're still innocent until proven guilty, why we would take that discretion away from the judge in that circumstance, why it would be necessary. And if it is necessary, you know, is there a larger problem that we're seeing over and over again? Or is that a consequence of state's attorney's office? Is that a consequence of parole and probation being understaffed, for instance?
I think some of that, I think some of your last concern that it would be wonderful to have, and I certainly support having more parole and probation officers that have more ability to do effective casework and say, hey, I'm the discerning eye between this individual who's not really a risk, is someone that's on the rehabilitation path. This individual is a dangerous criminal. They're a risk factor. So some of that goes into it, but with respect to the innocent until proven guilty situation and the presumption of innocence and the Fifth Amendment protections, let me put it this way. Keeping you incarcerated while awaiting your adjudication does not legally say that you are guilty.
But
when individuals appear to court to contest their guilt, we do not bring them in, with the sort of prison gear on. We do not inform the jury this individual was currently, we've kept this individual locked up. The judge denied a bail. None of that comes before the ultimate arbiters of innocence or guilt.
I understand all of that, and this is where I'll conclude, Mr. Vice Chair, is, again, as drafted, the concern is going to be the individual who maybe did something wrong or maybe didn't do something wrong, who has a charge that's pending. You mentioned that the courts can be backed up for however long they can be backed up. They certainly are in Baltimore City.
Sure.
And then they get a secondary charge. That second charge may be just as bogus as the first charge. We got a history of police misconduct in our city, so both of them could be very bogus. But now this individual is locked up, can't find his, and he loses his job. Now he can't take care of his kids. Then he has a child support situation. Then he loses his license. Y'all see how I'm pulling this all together?
So I would certainly suggest to you that I'm not saying that wouldn't happen, but I would suggest this, and you certainly know your community far better than what I do. But what I would say is that's probably the exception compared to the general rule of someone who is repeatedly charged with violent crimes and has a background and a history of prior convictions for violent crimes. While they're on pretrial release for a violent crime, they're charged with committing another violent crime while they're supposed to be, frankly, keeping to their P's and Q's awaiting their trial.
Yeah, I think the
So
difficulty is the
it's a question of
entanglement.
how often does that really happen?
I think it's the entanglement. I don't think it's as much of an exception as you may think, and this committee has seen evidence and testimony to that fact. But I appreciate you bringing the bill in for the conversation.
Thank you. And I think you're the sponsor of a bill, House Bill 1041. Is that correct? About that would affect the pretrial release conditions for people with handgun violations and things of that
That
nature.
was specifically referred to the court commissioner. They
Yeah.
would have to see a judge.
I looked at that, and I think that's
Right.
a good bill. I looked at that in preparation for that today, so I
Yeah, but it
appreciate
wouldn't
that
go,
effort.
yeah, it's a step before yours, but yeah, I
Yeah,
appreciate you.
thank you.
All right, thank you very much. Oh, wait, we got one more. Go ahead, Delegate Munoz.
Thank you, Mr. Vice Chair. I really appreciate you bringing this bill, Delegate. And the conversation you guys were just having, I think a lot of times in this committee, we have a struggle between protecting victims and protecting criminals. And this is sort of a disturbing issue for me. Obviously, we were all aware of this mother who was murdered here in Annapolis recently, and my husband was recently robbed at gunpoint at his pharmacy here by someone who, like you said, should have been in jail at the time. And he wasn't. He was out. The police were able to, apprehend him, and I'm super grateful that he was not released on bond this time. But, based on your experience as an attorney, your time here in the General Assembly, so many of the bills that come before us, we really grapple with the fact that we have to choose who we're here to protect and where that balance lies, because we don't want to harm, innocent individuals. Right. We don't want to put, burdens on the court systems, on our police, on our citizens. But at the same time, we want to, I think, uniformly protect our citizens from especially violent crime. And so with that balance in mind, how do you think this issue could, protect our citizens?
So I think what it really boils down to is we generally, is the conversation we've had, we generally already do this for the vast majority of defendants whose pretrial release decisions are made by district court commissioners. We have made a policy decision. District court commissioner, you don't have the discretion to let this person go if they have some of these same characteristics. All I'm suggesting to you is that obviously there is a problem with vesting complete and utter discretion in the next level of judicial officer, which typically is a district court judge. In some jurisdictions, you may get a pretrial release hearing before a circuit court judge, but not all jurisdictions. There obviously is a situation going on where those decisions being made are having terrible adverse effects for our society. And it's a very difficult question that we all have, and certainly you guys deal with it on a very daily basis. The balancing test, the dividing line between we do not want to bring people into the system unfairly who are innocent. We do not want to bring small-time offenders. We do not want to bring minor drug addicts who may be committing crimes to keep themselves out of poverty. We do not want to excessively punish them. We want to offer them opportunities for rehabilitation. I think everybody at this stage agrees with that. We're talking about serious crimes of violence, repeat offenders. Not my first time, many cases not my second time. I didn't get charged with stealing a car. I didn't get charged with, very minor drug sale. I didn't get charged with bad checks. I got charged with very serious violent crimes as defined by this legislature. If there are crimes in there that you don't like and think that's excessive, we have the power to take them out of the definition of violent crimes. We've chosen not to do that. And so I think that's where the balancing test lies. In my personal opinion, we've gone too far over the 9 years I've been here. The pendulum has swung too far toward the side of the criminal defendants' rights, the actual incarcerated criminal convicts' rights and rehabilitation, and we've gone away from trying to find that small subsection of people who are really committing the most heinous and horrific crimes and appropriately punishing them.
Because that's what we see usually with violent crime, is it has a very high recidivism rate. Is that correct?
There is a significant recidivism rate. I'm not a psychologist. I can't explain why that is, but I can only imagine that it takes a tremendous psychological toll on someone to commit a really serious act of violence. I mean, that's not normal behavior. And I think, when you do look at some of the studies, once you've done it once, it becomes easier. It would be unfathomable, I think, for most people in this room to think about shooting someone under almost any circumstances other than self-defense. But there are individuals who, for whatever reason, of all backgrounds, who once they've done it and they've moved on, the consequences have not, changed their life. I think it changes their perspective what they can do and what is within the realm of the possible for them. And those are the type of individuals that are scary. They're the type of individuals that are killing innocent people, that are committing these horrific crimes, and we need to just be honest about that and say we have to stop you from doing these things.
And so, in its like most simplistic form, if we really just boil it down, what we're talking about is holding violent criminals while they're going through the process and protecting lives of innocent Marylanders.
I think that's a fair way to look at it. Some people, if you let them out on pretrial release, even though they're charged with a crime of violence, may never do anything else. Some people will not. Some people feel that criminal lifestyle is something that they adhere to, and that it's very, very difficult to change that. I see it in my community. We have, I live in a fairly small city, and we have some individuals who are repeatedly charged over and over and over again. With the same, we just had an individual who was charged with killing his wife a week ago, who had already been arrested and convicted several times for serious physical assaults on women, and had never really been appropriately punished. Had gotten the proverbial slap on the wrist. You did 30 days, you did 60 days, you're back out. On to the next wife, killed her. And so there are people in the world of all backgrounds who will not comply with what we need them to comply with to be members of our civil society. And we have to be honest about that and find ways to prevent them from hurting the rest of us.
Well, again, I appreciate you bringing this bill because it makes sense to try and slow these crimes down before they get to, deaths of our neighbors, our friends, our family, because once someone's taken from us, we can't ever fix that. So thank you.
All right, looks like we're beginning now. We had Grammer, Boucher, Bartlett, and Conaway.
Thank
And
you.
see, in Ways and Means, this is when we would be like, what is going on in here?
Thank you, Mr. Chair.
Questions, people, questions.
And I'll be brief. So I'm working with Ryan Coleman. He's the president of the the Randallstown NAACP. And like Eastern Baltimore County, his communities are having real problems with crime. We went over 2 years of crime in Baltimore County. Baltimore County experienced 77 murders in 2021 and 2022. Out of the 70 suspects charged with murder, 90% were convicted of a felony.
Prior convicted of, yep.
Correct. 25 were on probation at the time of the murder. So you're talking about crime and violence. He's talking about, the numbers prove out for felons in Baltimore County. And that doesn't overlap perfectly, but it's a way to kind of look at this. Is that the historical course of conduct? That's how he looks at it. That I agree with it. Is that kind of how you're looking at this to help prevent violent crime?
Yeah, you're trying to come up with a metric. Nothing is perfect. You learn that from practicing law, from studying law. There is no perfect way to deal with every problem. So my suggestions, this legislation suggestions, is certainly at the discretion of the committee to maybe find a different way or to find a different metric or template for when someone, maybe it's 3 times that they've been, charged with a crime of violence while out on pretrial release. Maybe it's 2. I don't know. But that is exactly the problem, is that most of these serious violent crimes are being committed by repeat offenders. It's just happening over and over again. I can't imagine what that would be like to say my child, my friend, my mom was killed by someone who 3 months ago was charged with shooting at someone else and was out on the streets, or someone who 10 years, there was a woman, I believe in Baltimore City in a church, an somewhat elderly woman who was raped and killed by an individual who had already killed, this wasn't alleged, he'd already pled guilty 2 times prior in his life of killing someone else, and he got out. And within a very short period of time, he was working, I think, in some maintenance capacity, and he was working at a church, and he raped and killed an elderly. I couldn't imagine being that woman's family and thinking, man, this could have been prevented. This individual, maybe wouldn't have been there. So that's exactly the intent of it, is to recognize that a lot of these things tend to happen over and over and over again with the same individuals, and we need to put a stop to it.
All right, thank you.
Delegate Boucher.
Thank you, Vice Chairman. And
Wow, you're really up there on my left, Eric. I didn't see you coming over there.
thank you, Delegate Buckle. Two real quick questions. Do you believe that individuals file false criminal charges against other individuals?
I think so. I don't think that it happens very often, but I definitely know that it happens.
All right, thank you. And the second question is there a possibility that in acrimonious divorces that this can be used as a weapon to lock the opposing party up in the divorce proceedings?
Very, very unlikely, and I'll tell you why. When I say people file false charges against people, I'm talking about general charges. Serious crimes of violence typically would require a police officer to come out and investigate it more seriously before they would file these types of felony charges. If I wanted to say, hey, just make up a story, I was hanging out with Eric Boucher tonight, and he pushed me, and I want to charge him with second-degree assault, that could happen. That wouldn't necessarily fall within this ambit. On the other hand, if I wanted to say, Eric Boucher had a gun and was waving it around and shot at me tonight, and I know him, it was Eric Boucher, he shot. Before you would really get charged, the police would come out and investigate my story. They would seek some form of corroborating evidence 99 times out of 100, probably 100 times out of 100. So that could be a concern in some circumstances, but again, I think that's the very minor tip of the scale versus, as Delegate Grammer pointed out, over and over and over again, the recidivist, serious, violent career offender.
Thank you very much.
Delegate Bartlett, you still have a question? No, okay. Delegate Conaway.
Thank you, Mr. Vice Chair. Thank you, Delegate, for bringing this bill.
Thank you.
You spoke about the repeat offenders having never been appropriately punished. How did you come up with that conclusion?
I come up with the conclusion because obviously they were neither rehabilitated nor were they deterred from committing crime. When I went to law school, we were taught that the purposes of criminal law sentencing really are threefold predominantly. Number one, it's to protect the public by putting people away who would be out there to hurt other individuals. Well, obviously, if I put you away for a period of time and you left and you continued to hurt other individuals, the punishment did not change anything. The second reason is typically a deterrent effect. So it deters the general community so that people are like, hey, I don't want to do that because if I do that, I'm going to go to jail or I'm going to have such consequences it's going to so negatively affect my life. If people are repeat career violent offenders, obviously that message did not get through. And so I don't think that we can logically say, let's have a society where we allow people to commit murder, we put them in jail for a while. I'm not saying it's a short time, 10 years, 15 years, whatever it may be, of actual livable jail time. And then they come out, hey, you're good now. You murder someone else. You go back in for another 10, 15 years. You're good now. We let you out. You go out, you rape and murder someone else. We have to fix the problem, and we sometimes have to realize the sad, unfortunate reality of the human condition, that there are some people who you cannot rehabilitate, who are violent to their core, and you can't just let them go in and out of the system because they're going to cause terrible repercussions for others. It's sad. I mean, none of us want to think of other human beings like that, but it's a sad reality.
Well, I appreciate that answer. And what does their environment have to do with their reality?
I think it can have a lot to do with it, to be fair. I think children...
It might not be their nature, but because you put them in a certain environment,
they develop
that environment helps trigger off another part of their nature, which might be their survival skills.
I have a little 6-year-old boy, and I can tell you, I think every little 6-year-old boy in America is at core an innocent, good person looking to become a good man. I don't think that 6-year-old little boys or 10-year-old little boys or 12-year-old little boys are like some irredeemable boy. They have terrible nature. They're going to be violent. I do think that the way you're raised, I do think that opportunities you have or don't have a serious effect on decisions that you make as a juvenile, maybe as a teenager, certainly as an adult. But I guess my point with that, Delegate Conaway, is I support efforts to try to fix the long-term problem so that we're having less and less of these violent-prone individuals. But that doesn't fix the short-term problem of we've already got some of them. We've already got some of them who are far enough down the roadway that we're probably not going to be able to bring them back safely. And we have to be honest about that. That little 6-year-old boy, my son, and his playmates, they can be saved. We can create better environments for them so that they don't grow up to become violent-prone individuals. That individual who's already done 1, 2, 3, 5, 10 things and has been in and out, has already taken a life, done this, we may not be able to bring them back, even though you're very right. You know, it's not like blame them. They're horrible human beings in their heart. Maybe some of their environment did create it, but we can't fix that now.
Okay,
after they've done those things.
Thank you very much.
All right, Delegate Phillips.
Also hard on my left. Like that's we don't have people quite far back so far in our committee. Like, where you guys coming
Delegate
from?
Buckle, how are you? So you made a comment. Some people are violent to their core.
Yes.
And there are other people, probably most people that are, would you agree, that are not violent to
Yes.
their core? Would you also agree that fact patterns can be complex when it comes to criminal-related matters? Would you agree with that?
I think in general they can. Sometimes they can be very, very simple. Sometimes you have cases where someone says, you know, I have 3 eyewitnesses who observed Joe shoot Pete. We were there. We saw it. The cops arrived. We took a ballistic test of the gun. It matched. That's a pretty simple fact pattern. There are obviously other cases that could be more complex about, you know, someone is really asserting their innocence of, I didn't do this, you don't have any evidence to this, you know, there can be other circumstances.
So when those other circumstances occur, our system currently allows for some type of fact finder, right, a judge, to review that situation and has some level of discretion today. In this case, they would have discretion today to make the determination of whether someone should be placed on pre-release.
Pre-trial release. That's right. That's correct.
So in a complex situation, you're suggesting this is a shall versus a may. Is that how I understand? That's how I understand.
Yeah, I think that's a fair, yeah. It's we would be taking the judicial officers and putting them in the same posture that we've chosen to put the district court commissioners, who are mandated not to release people charged with some of these same crimes. So then what happens is the person goes for the district court commissioner. District court commissioner says, I can't let you out. They then petition to go before a judge, and the judge says, okay, here's your bail. You can go.
And so one of the reasons we've judges are actually either appointed or elected in some way because we are providing some level of trust that they will make appropriate decisions based on the fact patterns presented to them. Would you consider that?
I think that there's definitely a role for judicial discretion in many cases, in many decisions, but I also think that in many cases the legislature gives a pretty strict prescription of what should happen. We define elements of crimes pretty specifically that you can't sort of lawyer your way out of. You know, if you have this is what you did. While we do not have very many what I think would be characterized as mandatory minimums sentences in Maryland, we do have some. And we certainly have made legal decisions and legislative decisions to set penalty parameters. That we don't just say, well, you're the judge, you just get to decide, you know, what happens with this person. We set parameters. And that's really what this is about, is setting a parameter for these rare individuals. I don't think it's a ton of individuals, but it's the individuals who are causing the most harm in our communities. If you match up these factors, you're going to have to not be on pretrial release until your case is adjudicated.
But we set those parameters, the parameters that you just described are set after there is an adjudication.
I think the parameters for pretrial release are set before the adjudication.
The ones that you were just describing in terms of sentencing, in terms of, those are set after those parameters are provided to a judge after he makes or the jury makes an adjudication. Is that fair?
Sentencing, absolutely, yes. I mean, 9 times out of 10, you know, I don't, the public defender's office they certainly do this for a living. I think statistics used to suggest somewhere between 90% or up of all criminal cases do not ever have an actual contested adjudication of guilt or innocence. They are either dismissed by a state's attorney who, after they review the evidence, believe I cannot proceed to prosecution, or more often than not, they are resolved through some type of plea agreement that typically has the defendant admitting to some degree of culpability. As you all know, I'm sure, oftentimes in crimes, the individual was charged with 3, 4, 5, 6, 7 different charges that their conduct may fit into that box. And then in the plea agreement, that is usually reduced to one or two of the charges with an agreement as to time served. That's how the vast majority of cases work in the real world. There obviously are examples that go outside of that, but in the vast majority of cases, I think these individuals would be still incarcerated at their local detention center while awaiting trial, and then if they agree to some type of a plea arrangement, the time that they spent there would be credited toward their ultimate sentence. The difference would be is during that interim period, they would not be free to commit other crimes, essentially.
I understand this idea of trying to remove violent people from the streets, and I actually agree with that concept. I'm just having a challenge of incarcerating people for extensive periods of time, given our system today, which could be months, could be a year, while they're awaiting a trial, ultimately, at some point, maybe, to be found innocent of their crime. To me, that is a travesty. So how do we, if we don't give the fact finders the ability to, I'm just trying to understand.
Sure.
The fact finders have the ability to question the person's veracity and have some sense of the person's background before making a decision as to whether they go on pre-release or not. Taking that away, that discretion away, how does that work for that other person who goes through the whole process and spends a year in jail? Help me understand that.
I think to be fair, it won't work. It won't be perfect. The hardest lesson that I have learned practicing law, and I don't practice in this particular field, but I'm close with people who do, and the hardest lesson I've learned being a legislator here, not going to get it perfect. Any law you pass, anything you do, any case you get involved with, if there's 100 circumstances that come up, one of those circumstances might be a tough situation. My value system, and maybe it's different than others, and that's certainly acceptable. My value system suggests that if we have 100 situations and one of them is going to go south, one of them is going to be unappealing, it's not going to be what we want, I can live better with that one situation being an individual. And I also want to put, they do have speedy trial rights. I know COVID screwed a lot of things up. Hopefully we're out of that period. You do have a constitutional right to a speedy trial. So it's not as if they're held, forever awaiting trial. They have a right to elect a speedy trial, and the courts need to bring them to justice within a reasonable period of time. But I guess to get back to my analogy, if we have that one hard case, I would be more comfortable, not happy, but I would be more comfortable saying that one hard case was the 1 in 100 individual who was actually found actually innocent at trial, and they did spend 2 months, 3 months, 4 months incarcerated. We obviously have a system here in Maryland where individuals who are wrongfully convicted, we've established a system where they can seek compensation for that. I'd rather have the one case be that than the one case of we were a little too lenient, we relied on the discretion, we let everybody out, and you killed somebody. You killed my next door neighbor. You killed somebody across the street. There's nothing we're going to do that's going to get it perfect.
We're going to move on to the next, and hopefully the last question for the
You don't have any questions for me, Delegate?
First witness on our second bill of the day. Delegate Young has a very pressing question on this extended meditation on bail.
Don't let him do that to you.
Second bite, I apologize, colleagues, but Delegate, you referenced the murder at the church.
Yeah.
That was my district.
Terrible.
My question is going to be how that applies. I'm going to tell you now. It was Evelyn Player, 69-year-old senior.
Yep.
She was killed by Manzi Smith. He was just sentenced to 50 years. Now, Manzi's not a good guy. He was convicted of rape in 92, sentenced to 30 years. He was convicted of snatching somebody's purse. And I think, I got it right here, 2012, sentenced to 8 years. Served his time, was on parole and probation. His parole and probation had ended. And then he killed Ms. Player. My question again, I'm not sure how that applies. And I raise it because, look, I'm here for making our streets safer. My district has a lot of issues. But I'm not here for, and I've said this to another member of your caucus, I'm not here for using the tragedies in my district as leverage for bills that don't apply to the bill that is at hand.
So my reference to that situation wouldn't apply to this bill. What it would apply to, and it was really in response to, I think, a question that Delegate Conaway had asked about the more general sense of where we are on criminal justice and where we are on punishment.
You said it, to clarify, you said it in response to Delegate Grammer's question.
I did. But I want to make clear to you, you just said that a man in 1992 was convicted of raping a woman and was sentenced to 30 years in prison. I went to law school to avoid math, but 30 years from 1992 is 2022. He was obviously released
but again,
for a very short period of time,
Delegate,
got out,
your
committed another
bill
crime, and another short
to
period of time. If you were
pretrial
okay with that,
release.
that's fine with me.
Delegate, you're in this committee. Your bill refers to pretrial release of an individual charged with a crime. This person, in that circumstance, was not charged with a crime until until after he killed Ms. Player. So I'm simply asking you, when you're referring to any circumstance in this committee about a bill, let it refer to the bill. Let it be applicable to the bill.
I appreciate your advice, but what I'm suggesting to you is I think we're a really soft on crime state.
All right, that's a different conversation. That's a different conversation.
All right,
This bill is part of that.
We're gonna move on. Delegate Conaway.
Thank you, Mr. Thank you again. Be clear on what you said. Did you say you would rather in person in jail than to let a guilty person go?
What I said very clearly is if there's 100 circumstances and one of them goes south, I'd rather have it be that someone suffered a short period of time in local incarceration than whether someone killed someone. Because, you know, when you kill someone,
you actually
they don't get back.
You rather for the innocent person to be kept in jail.
No, I'd rather never have an innocent person
who didn't do it, but there are circumstances that points to they may have done it. You rather for them to stay in jail and then be found innocent than to let the guilty person go.
I guess the way that I would say it, Delegate Conaway, is would the obverse of the question apply? Would you rather say we need to release everybody on pretrial release, and we understand that as a result of that, there's going to be 20 or 30 or 50 more crimes of violence committed, but there might be one individual out of all those individuals we released on pretrial release who is honestly innocent and gets let off? The obverse of every question applies, and that's my point is we can't be perfect. We're trying to be perfect.
Well, you might persecute the wrong person. So
you might, and that's a terrible situation.
If you feel comfortable with that, then that's your mind.
I'm not suggesting to you I feel comfortable with it. I'm saying I also don't feel comfortable with individuals who are repeatedly charged and convicted over and over and over again for violent crimes being back on the streets and committing more violent crimes. I don't feel comfortable with that. Never.
All right, thank you very much. We are going to move on to the opponents to this legislation. There are two signed up virtual. Okay, they're coming in from the Office of the Public Defender. We'll start with Elise Desiderio and then Michael Beach.
Good afternoon, all. I'm Elise Desiderio with the Office of the Public Defender, urging an unfavorable report. This bill would unreasonably restrict pretrial release. It would infringe on accused people's constitutional rights and would cause an unfair and unnecessary increase in the number of people in jail pretrial. Here in Maryland, anybody can submit an application for statement of charges with the district court commissioner alleging a crime has been committed. And often an arrest warrant is issued based only on what that complainant says, without corroboration or further investigation. With this bill, somebody motivated by ill will could go to a commissioner, allege, say, a first-degree assault, and effectively ensure the incarceration of their target person for a substantial period. Today, at bail review, defense attorneys can show improper motives like this and explain why their client is not so dangerous or unlikely to return to court that they shouldn't be released pending trial. And importantly, there's already a rebuttable presumption under 5202C3 that a person charged with a crime of violence who's been previously convicted of a crime of violence will flee and pose a danger to another person or the community, and so shouldn't be released pre-trial. But this bill would prevent affected people from arguing for their liberty at all, even though they're still presumed innocent. We have to remember the Supreme Court's words in U.S. versus Salerno in 1987. In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. And Preventative detention based on dangerousness is only acceptable when limited to specifically dangerous individuals and subject to strong procedural protection. And it requires a case-by-case evaluation, requiring discretion. This bill creates a category of people who are robbed of any ability to argue for their liberty based solely on unadjudicated charges or their past, so we urge an unfavorable report.
All right, Michael Beach, when you're ready.
Thank you, members of the committee. My name is Michael Beach. I'm the District Public Defender in Montgomery County. I testified against this bill last year and submitted written testimony. It's the same bill. It's still unconstitutional. As my colleague indicated, there are rebuttable presumptions in the statute. This creates an irrebuttable presumption. Irrebuttable presumptions violate the Due Process Clause of the Constitution and Article 24 of the Maryland Declaration of Rights. I come at this with, as of July, 20 years of experience as a public defender, 10 years in leadership, and for the last decade, I assign the felony cases. I've worked in Prince George's County, been in leadership in Southern Maryland, and leadership in Montgomery County. The examples that are being cited are tragic, but they are the extreme examples. They are not the rule. The rule is what are the things the other delegates, like Delegate Young, touched upon. People do get falsely accused. They get falsely accused all the time. And what I see every week are first-degree assault charges, which are crimes of violence, brought that go absolutely nowhere. Either after 30 days at the preliminary hearing, the felony gets dropped, or the case gets thrown out altogether because it's frivolous. Sure, crimes of violence are underreported, but what is reported, there is a startling number of false allegations. As my colleague indicated, you can walk in, and I've seen these every week, handwritten, barely legible allegations by somebody with an axe to grind, that if they somewhere buried in this barely legible paragraph put the word choke, this person is then charged with first-degree assault, which is a crime of violence. If they do that twice under this bill, they will be held for a minimum of 30 days without bail. If they happen to be a returning citizen who's doing well, has a job, taking care of their family, but has a prior crime of violence, and someone with an axe to grind does this, they're going to, just like Delegate Young said, they're going to get held for 30 days, they're going to lose their job, they're not going to see their family, and they're going to suffer all sorts of other consequences. This bill is unconstitutional, and it will be an unfavorable report on it, and I'm happy to answer questions about how it really operates in our day-to-day work.
All right, I don't see any questions, so it looks like y'all are off the hook, and that's going to conclude the hearing on House Bill 736. We're going to go now to House Bill 731 from Delegate Wilkins, and it looks like it's just you. Is that right? All right, whenever you're ready.
Thank you so much, Mr. Chair. And hello, everyone, members of the committee. It's great to be here again. I am Delegate Janelle Wilkins. I'm pleased to present HB 731, and I am back again with another police accountability bill. In 2018, Maryland officer Michael O'Sullivan was found guilty of perjury and misconduct in office for his testimony given in a district court trial on June 4th, 2018. Under oath, Officer Sullivan testified that he saw Yusuf Smith reach for his waistline and throw a gun before fleeing from the police. It was later discovered through the body-worn camera footage that Officer Sullivan did not and could not have seen what he testified under oath while in court. The victim of his deception, Yusuf Smith, was charged with illegal possession of a handgun and other firearm offenses and served 70 days in jail as a result of this officer's lie. He also suffered $50,000 in economic damages. Not only did former Officer Sullivan's actions cost a man his freedom, it also cost the jurisdiction $100,000 when it settled the case. Unfortunately, crimes committed by officers and convictions happen more than we would like. The Bowling Green State University crime database shows that between 2005 and 2016, at least 190 Maryland officers were convicted of various crimes related to sex-related crimes, violence, or perjury. That doesn't even include the increased convictions that we've seen recently in recent years. The question that my bill asks is, should officers convicted of serious crimes while on duty retain their pensions and receive taxpayer-funded checks from the state? My response is no. O'Sullivan, who I just referenced, will receive his full pension. HB 731 requires that an officer who is convicted of a felony, perjury, or misdemeanor that's related to truthfulness in the course of duty shall have their retirement allowance forfeited. This is after all appeals are satisfied, and it also takes into consideration any domestic relations orders, the severity of the crime, the amount of money, and other facts of the case. While forfeiting a pension is a very serious step, this really is something that only applies to crooked officers. And I also want to point out that currently, all of us and constitutional officers, our pensions are currently forfeited. So this is not a new precedent when there is a crime that any of us would be convicted of. So I urge a favorable report on this bill, and I do want to note that I believe Ann Garthop from the Maryland State Retirement System is here for any detailed questions related to the pension system. I urge a favorable report.
Any questions? Sorry, go ahead, Delegate Munoz.
Thank you. My question is, these pensions and benefits, do these go to the spouse and children of the officer after conviction?
You're saying under this bill, would it go to the spouse?
No, without the bill, like currently. So if this officer has done something awful and they're, put in jail or whatever, and they have a spouse who doesn't work and children that need to be supported, would those benefits go to them?
Currently, my understanding is that there is a mechanism for officers who are in prison, who are serving time, to be able to get those paid directly to them while in prison. That's my understanding from a conversation last year.
So if they're getting them directly and then providing their family with that support, under your bill, would the family then have no support whatsoever?
There is an opportunity under this bill, if there's an existing domestic relations order, so alimony, things like that, or a specific beneficiary, that it would not impact that. And there's also an opportunity for a spouse or a dependent to file a claim to request from the court that they receive the benefits directly.
Okay, thank you so much.
Thank you.
Delegate Bartlett and then Simpson.
Thank you, Delegate Wilkins. So if you can, and if it's going to take too long, we can talk offline. But I remember fighting hard for this in subcommittee. Did it get taken, so it got taken out of the police accountability bill?
That is a great question. Thank you so much for asking, and I didn't plan that. But for the committee's awareness, we did pass an HB 670, the Speaker's bill, through the House. These, an opportunity to forfeit the pensions of officers, so something very, very similar. Unfortunately, during conferencing and the Senate and all of that, it was taken out. So I do want to point out that the House has voted on this before and passed it before within the Speaker's bill, HB 670.
Thank you.
All right, little technical. Looks like it's working. I have a question for the State Retirement Agency, if that's possible, for clarification.
Hi, I'm Ann Gothrop, Director of Legislative Affairs for State Retirement. And Delegate, if I could just take one moment to tell you, this is my 23rd session and the first time I have ever been in this room. So I'm a little nervous, I'm not going to lie.
And full disclosure, we work together.
Yes.
Okay. So my question to you is, if an officer at the park, let's say at the Park Service, rapes some folks and gets convicted of rape and perhaps murder, is there anything that currently in law that would prohibit that officer from receiving their pension?
In your hypothetical, because we don't speak directly about anyone in particular's pension.
Absolutely, and I would never.
So in your hypothetical, there is nothing currently in the law that, except for, as the sponsor pointed out, except for legislators and constitutional officers, there's nothing in the law that would direct us to forfeit the pension of that individual.
Okay.
So that individual, in your hypothetical, would receive, depending on which system they were in, and this is true of all state employees, they would receive a state pension.
And is it true that there is only one thing that would end up, it's not, obviously, the individual would receive a benefit. So the only law out there that restricts a benefit would be what, I think it's called a Slayer's Law. Can you explain what that?
So that is separate from this, and there's actually a provision, I think, in your bill that speaks to, that this does not forfeit beneficiary benefits, but the Slayer's Law would speak to that. I believe that's in Estates and Trusts. It's been 23 years since I practiced law. So I believe it's in the Estates and Trusts article, and if a trooper, let's say a trooper was married to a DNR police officer, and the trooper murdered his wife, but he would not be able to get the survivorship benefit from the DNR police officer's pension, but would still collect the state trooper pension.
And obviously, we wouldn't be talking about anybody specific.
No.
So the follow-up question would be, in this bill, I think you already said that the beneficiary could still receive a benefit.
Yes.
It would just be the officers. Is it in this bill allowing for, if I serve my time, let's say this is me and I'm convicted and I serve my time, would I then start receiving my benefit?
No, not under this bill. It would be forfeited.
If I am someone who, I was a great employee for 20 some odd years and then I have kind of fall short, is there any way that I could receive part of my benefit?
There is an opportunity under this bill for an officer to file a claim and request from the court partial payment. So that's where the court can take into consideration all the things that I mentioned, the severity of the crime, the impact, their spouse and beneficiaries and all of those things. However, I would say that when we are talking about these types of crimes, we're talking about felony level crimes. We are talking about crimes that are committed while on the course of duty. These are usually not, oh, I just accidentally, like the example that I just gave, I just accidentally told a complete lie and was convicted by a jury of doing this. So I would really emphasize that these are not just, oh, I made a little mistake sorts of crimes.
Very serious, egregious, and we're talking found guilty.
Right, found convicted, absolutely.
And just to follow up, and then I'll be done, is that currently there is nothing in law that the state retirement agency, that would prohibit them from paying out that benefit, even if someone murdered someone while they were, or any of these, like I said, park ranger, raping people at the park.
We are required to pay out the benefits.
If they are entitled to it.
Yes.
Okay, thank you.
And Delegate, I would just add that the reason I came up with this bill and wanted to introduce it was because of this exact case that I mentioned, where during the proceedings, the elected officials who were looking at the settlement, looking to approve it, they were literally having the conversation, is there anything that we can do? Can we have to pay out $100,000? Can we recoup the pension benefits? Is there any process? And there's nothing currently for law enforcement officers to be able to forfeit those pensions. And so this bill would be the opportunity to do that.
And I'm sure there's anguish on the folks that have to pay it out, knowing they're paying someone who has been found guilty of a very terrible crime.
Thank you, Delegate.
Delegate Conaway and then Phillips.
Thank you, Mr. Vice Chair. Thank you, Delegate and witness, for coming in today. as I understand it, law enforcement is a very stressful job. And under stress, sometimes a person might crack underneath of the pressure. I was wondering, is there any kind of medical exemption that would allow the officer to keep their pension even if they were found guilty?
There is not currently a medical exemption in this bill. That's certainly something the committee could consider, but currently, no, there's not.
Thank you very much.
Thank you.
All right, Delegate Phillips, Crutchfield, and Erican.
This is I think this is probably, my question is about the vesting of a pension and the timing. So if a officer were to commit a criminal act in the course of duty, be aware that they've probably done such thing, decide tomorrow to retire, then they are charged, and at that point they have begun receiving their pension. Does this still apply? So once a person is vested, has begun taking their pension, you go back, 60 days, and you find out that there was an inappropriate act. Does this account for that as well?
Great question, and it gives me an opportunity to explain something else in the bill, and I will get to that. This bill is prospective, so this is for crimes that take place after July 1st, 2023, and we can only recoup and forfeit pensions that would be after that time, with the money that was accrued after that time. But when it comes to, so let's just say in your example that, this happens next year, and the officer, we find the officer retires and the pension system becomes aware of it. Yes, the bill does address that in the sense that the pension payments would stop then, and there's an opportunity to also recoup.
All right, let's try this again. Crutchfield, Tomlinson, Embry.
Thank you, Mr. Vice Chair. And Vice Chair Wilkins, really good to see you, and thank you for the bills that you have brought in the last couple of days. Really appreciate those. So just a clarification question. What law enforcement organizations are actually covered by your bill?
Thank you so much, Delegate. That is a very good question. It would cover the Maryland State Police. It would also cover various police officers like Department of Natural Resources who are in the pension system. Basically, any of them that are in our two state pension systems, and our local police officers as well would be included in this bill.
Okay, great. So local police agencies as well?
Yes, would be included.
And would it even go down to like the municipalities, or how far do we go down? And maybe you may be able to address that.
Well, if they're in the pension system, sometimes it varies for jurisdictions, but a lot of times the local ones, they pay into and they're part of the state. So a lot of them, yes, would, but there may be some that have sort of their own pension system.
Okay, do you know if Montgomery County's police department would be included in that?
It was so interesting. When I was reading the fiscal note, the fiscal note actually says, and I did not know this, that Montgomery County has a provision to forfeit pensions of convicted officers, which I did not know, and I was surprised to find out.
Great.
And Baltimore County, apparently.
Okay, well, thank you very much.
Thank you.
All right, Tomlinson, Embry, Valentine.
Am I on? Okay. Thank you. This question might be best for a guest from Maryland State Retirement. Well, either one of you really. This bill just has to do with forfeiting the benefits for law enforcement. Are there any other occupations that fall under the state pension system that currently you can get your benefits taken away?
Yes.
Okay.
Yours. The legislative
All right.
pension plan.
Exactly.
And I will say, again, I can't speak specifically to people's pensions, but we have enforced the forfeiture provisions within the legislative pension plan.
Okay,
And
so.
Delegate, if I can quickly add, when it comes to our pensions and also the constitutional officers who these provisions apply in concept, in terms of forfeiture, there is no consideration at all. There are questions about what about the spouse and beneficiaries and children. None of that applies. There's no questions asked when it comes to our pensions and the forfeiture. And I just really want to point that out, that we are accounting for that in this bill. But when it comes to the existing provisions in law regarding elected officials or members of General Assembly, specifically and constitutional officers, those considerations are not a part of that process.
Okay, yeah, and now that you say that, I'm literally looking at the list right in front of me in your testimony. So outside of Governor, Lieutenant Governor, Attorney General, Comptroller, Treasurer, Secretary of State, all members of General Assembly, are there any other, more normal occupations, let's say teacher, park ranger, anything like that? There's no other?
None.
Okay, so if a teacher gets found guilty of a felony, perjury, misdemeanor, fired, and everything, they still can get their benefits?
Yes.
Yes, correct.
Okay, thank you.
Thank you.
All right, Embry and then Valentine.
Thank you, Vice Chair. This is, I'm sure, my ignorance of the pension system, but I was wondering if you or your guest could speak to the section that talks about the IRS determination that the forfeiture would negatively affect the tax-qualified status of any of the systems. I just didn't understand what that meant.
I think we're trying to not bankrupt the system. So, I mean, it's, as I mentioned, there are about 190 between, I think, up to 2016. So let's just say, for example, for some reason there were like a whole lot of pension forfeiture that would cause the system to be disrupted. Basically, this bill says that, we would pause and not do that if it was a problem for the system. But I would imagine that, you'd have to see a ridiculous amount of forfeitures happening at the same time for there to be any impact on the pension system.
Thank you.
Delegate Valentine. Yeah.
Thank you, Mr. Chairman. And thank you both for being here today. I have two questions because I did not see it listed. Is this only applicable to defined pension plans? And by that I mean the pension plan is not a 401k, a 457, or any supplemental plans. Is this specific to defined plans?
I believe so. Yes.
It's only the state pension system, defined benefit plans.
And all of the local pension systems, that would cover any local system. And my last question is, does this only apply to benefits, or would this also be employee contributions made by the officer during those years of service?
Thank you. You all are asking the questions on things I did not get to speak on in my 2 or 3 minutes. That's a very, very important question. Legally, we cannot take away the funds that a law enforcement officer pays into, so the money that's coming from them, the employee, into the system. So this is actually referring to the funds that are the state taxpayer dollars that the employer has contributed. That is the part that would be forfeited.
Thank you.
Chair, briefly, so when you pay a fund into a pension, it doesn't pay $10 in, I don't get $10 out. It's invested, it accrues, it grows. Just curious, how does the bill account for that?
So the bill, your benefit, when you go to retire, your benefit is based on your years of service, your final average salary, and the benefit multiplier. It's the percentage of your final benefit that you're earning each year that you're working. That is funded in part through your member contributions and in part through employer contributions that are put in for you. When a member leaves, if they leave vested and they withdraw their contributions, they're always entitled to their own money. They can never get the state's money back. That always stays in the plan. So this is really, to Delegate Wilkins' point that she just made, this is really focusing on forfeiting the state employer piece of the pension.
Okay, thank you.
All right, that looks like the end of the questions. Oh, we got one more. Go ahead. Yep.
And I don't want to speak for Delegate Grammer, but I think What I was inferring about that question was what happens to like accrued interest on the contributions? I know when you get your statement, you have accrued interest on your contributions.
So the bill includes, when you get your member contributions back, it includes any interest that's accrued.
Thank you.
All right. And that's admittedly a clearer understanding of the bill than I had last time we did this too. So thank you. We have two people signed up unfavorable, Michael Davey and Rebecca Smith, if they're here. And whenever you're ready, whoever would like to begin.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Michael Davey. I am the General Counsel to the Maryland State Fraternal Order of Police, and we are requesting an unfavorable report on House Bill 731. This bill is basically a carve-out for law enforcement. It's all this bill affects are law enforcement officers. House Bill 731 would allow for forfeiture of pension benefits from a law enforcement officer who's a member, a former member, or a retiree of the state police retirement system, the law enforcement officer's pension system, the employee's pension system, or local pension systems. It would give the authority to these pension systems to not pay the retirement benefits that officers have earned over 10, 15, 20, 30 years based on a conviction of a qualified crime of felony, perjury, or a misdemeanor relating to truthfulness and veracity. In 2021, the Police Accountability Act was passed. It already put in place times when police chiefs can suspend police officers without pay. They can be suspended if they are charged with a disqualifying crime, a misdemeanor committed in the performance of their duties, or a misdemeanor involving dishonesty, fraud, or theft. That's only if charged they lose their pay. Now, also under the Police Accountability Act, if they're convicted, a chief can terminate the employee without a hearing under the Police Accountability Act for a conviction or a PBJ of a felony, a conviction of a misdemeanor committed in the performance of their duties, a misdemeanor related to domestic violence, a misdemeanor of second-degree assault, or a misdemeanor involving dishonesty, fraud, theft, or misrepresentation. Along with the officer being terminated from his employment, he's also, obviously, if this bill passes, he's going to lose his pension, which is going to have a major negative effect on his family. The innocent spouses and children of these officers will be deprived of financial benefit at no fault of their own. Additionally, recruiting is already a problem in this state. Trying to get qualified individuals to become police officers and maintain their employment as police officers, knowing that this now is over their head, and after 20 years they could lose what they were earned, is going to be make it very difficult to retain and recruit qualified individuals. If this bill is even to be considered, it should involve every employee of the state and every employee of a local government that has a pension. You shouldn't just carve out police. Thank you.
Thank you, Vice Chair. My name is Rebecca Smith. I am General Counsel for the Maryland Troopers Association. Pensions are a part of compensation earned by these police officers. It is not a perk that should just be taken away. This bill would take money that's earned and that is not necessarily linked to any crime for which a police officer is found guilty. You're talking about any crime, not just a crime that involved money or their earning capacity. In these situations, like Mr. Davies said, officers could be suspended without pay, terminated, and then lose their pension. And the person that is going to suffer is the family in this situation. Who's going to support the family when the breadwinner, usually, loses their job, they haven't been paid because they're on suspension, and then they lose their pension? The taxpayers are still going to end up responsible for these folks. Families suffer, and there is no provision in this bill for the families to get the full pension benefit in these situations. A family member within a year of the forfeiture will be able to apply for a partial payment. There's still going to be something taken away from these families. There's also a lot of ambiguity with this bill. When the courts are making a decision as to how much of this partial payment should be refunded back to the officer, if any, or the family, the factors that are involved are very open-ended and aren't going to provide very much direction to these people. Also, just a quick point. When you're a retiree of the Maryland State Retirement and Pension System, you don't have a beneficiary, so to speak.
Beneficiaries involved when you pass away. Your beneficiary gets your pension. While you're an actual member, your family doesn't get anything, if that makes sense. I think that's to clear up some confusion. Right, it goes right to the employee, just to clear that up from before. Thank you. We asked for an unfavorable report.
Delegates Kaufman and Simpson.
Yes, Mr. Davies, it's nice to see you again.
Nice seeing you, sir.
Help me understand, because the way I look at the Wilkins legislation, you say it's a carve-out for police, but I look at it more about parity legislation, because if we get in trouble, if I rob a bank, if I do whatever, if I'm found guilty of something, just like Joe Schmo officer, if this were to pass, I would lose my pension as a delegate. So to me, this just puts officers on parity with me and all my wonderful colleagues sitting here if we do something wrong. So if you could just elaborate on why this isn't just a parity bill with the legislature to put us on the same footing. And then my second question, then I look forward to your response, is if I'm a father and I lose a job, but I work in the private sector, not for a police officer or something, could there be financial consequences for me? For my family, I think there would be, because Rebecca, I think you said your name was talking about the financial consequences for people if they would lose their pensions. Are there not financial consequences for every family who has a member in it that loses their job? So thank you.
So the answer to your first question, yes, this would be parity with the legislature, but nobody else. Not teachers, not anybody else involved in the pension system. There are a lot of people, a lot of employees in the state who are members of the state retirement agency, whether it be the employee system, whatever. There are a lot. Basically, I believe this is a carve-out beyond just the legislature, because it affects law enforcement and no one else in this bill. As it pertains to financial consequences, of course there are. But you have to remember, when an individual takes a job as a law enforcement officer, they look at a lot of things. It's just not the salary they're getting paid. They look at the benefits, the health care benefits, the pension that they will receive once they do their 25 years or 30 years, depending on what system they're in. There's something they may give up less salary, but they could get in the private sector in order to take a job in a law enforcement agency for less money, for the knowledge that they are going to receive, knowledge they are going to receive and their family is going to receive once they do their service time. So yes, there is a financial consequence for everybody who loses their job, but I think law enforcement officers, when they take this job, take that into account as to what their pension benefits are and plan for their retirement for them and their family based on that.
Thank you.
Thank you, Mr. Davies. So I have a question for the allot, or the 200,000 people who are in the pension system currently enrolled. Would you support this bill if it were amended to apply to everyone, all government employees? Would you support this before? Because remember, this is a qualifying crime which someone has been convicted of. Specifically, it is a criminal offense that someone has committed while they are doing the performance of their duties. Not just any crime. This is something that is committed while they are performing their duties.
I can't say that the FOP would ever be in favor of anyone having to lose their pension based on what they've earned. But if it affected every employee, I think we would be more amenable and not protesting against it as much, if that makes sense.
And I realize it's a very long bill, but it does look like Delegate Wilkins took a lot of time in preparing this and made very clear they are not losing what they put in or the interest that is earned.
Yes, there have been a lot of amendments or changes to this bill as opposed to the bill that was introduced last year. There's no question there are a lot of parts that are better protection than in the previous bills. But our position with the Fraternal Order of Police is we would be opposed based on how this is written.
And as stated, Although normally beneficiaries would not receive a benefit unless that individual actually died, interesting enough, Delegate Wilkins actually considered the beneficiaries in being able to petition and receive a benefit in lieu of, which is not normal.
So in this bill, within a year of the conviction of the employee, the family member, the spouse, could go to the pension system, or actually go to the court.
Right, they're not going to go to us. We're
No.
not that good at
Been there
doing
many
that.
times,
We don't have
and-
that kind of power.
They will go to the court and request it. How long will that period take? By the time the benefit is cut off, these family members could have their house in foreclosure. They will immediately lose their health care benefits. It's a major problem for the families, and obviously the income if it was a single income family.
And I'm glad you said that. I'd like to have that on a pamphlet so that people would consider all of those things before they would commit one of these offenses in the course of their duties. Thank you very much.
All right, that looks like the end of the hearing on House Bill 731. Thank you very much.
Thank you for your time.
We're going to move now to House Bill 661 from Delegate Lewis. And it looks like you have 3 people up with you: Matthew Pica, John Giannetti, and Adrian Muldrow.
Mr. Chairman, we signed up for Martin Schwartz was able to change. Can you take my place, please? We're trying. We signed him up. There must be some kind of system problem.
You have someone that's taking your place for MCD. Okay, go ahead.
Chair, Vice Chair.
Whenever you're ready.
Members of the committee, it's good to be home, as I would say. First, I just want to say thank you guys for the yeoman's work that you all have done over the last couple of years in helping to reform, particularly our prison system, to make it more fair and equitable. You all did the legwork for the Juvenile Restoration Act, and we've been constantly chipping away at trying to make sure our prison system is one that is attuned to rehabilitation and preparing folks to come home, which is the impetus for this bill. Senator Chris Weston and I met at a 1-year anniversary of the implementation of the JRA at the Francis King Carey School of Law back in October. And as we were hearing the challenges of so many of those who had come home after serving in prison for 30 years, we thought that we needed to do a comprehensive review of the reentry program in the state. And I want to state, this is my personal opinion, not anyone else. I believe that we should start having the conversation about reentry from the moment that someone enters the carceral state, not 6 months or a year before they come home. And that review should continue long after they come home, because particularly when you think about the folks who have been incarcerated for really long periods of time, 20, 30 plus years, it's going to take longer than 6 months to get back home, right? That comprehensive view should include, of course, housing. It should include mental health support, health care, getting an ID, transportation, obviously access to employment, and much, much more. We do know that amendments are coming to add other folks onto this bill. We took an initial review, and I asked the senator to put it in. There's some folks that are on there, others that didn't make it, but we've already talked, and we plan to add others on. The members of my panel will tell some of their experiences and stories, both organizations who they think should be on there and voices that should be on there, and I'm in full support of that. Thank you guys for your time, attention, and your service to the state of Maryland. Thank you. Oh, and also for the record, this is Delegate Janice Lewis.
Okay, thank you. Members of the committee, Mr. Vice Chair, John Giannetti for the Maryland Criminal Defense Attorneys Association. I admire what you all do. It's a great committee to serve on. I miss the time that I was here. This bill is important, and I feel so good sitting next to a superstar of the legislature here. For those of you who don't know, he not only does his work here in the legislature, he also has gone to the Rules Committee, which is the folks who actually are finding out the rules for the courts and getting that stuff done for the juveniles in our state outside of the legislative purview. So he's doing some great stuff. We just wanted to come and endorse what Senator West and Delegate Lewis were trying to do with this committee. With this task force. It seems to be not very controversial. It's a study. We'd like to be a member of it, but we're still in favor of it if we're not a member. Criminal defense attorneys, both the public defenders and the private attorneys that belong to our organization, represent criminal defendants, sometimes even after they've committed crimes. And we see firsthand, our members see firsthand what problems they have getting back into society. And sometimes that's really at the crux of what is a problem about why they are become recidivists. So I ask that you endorse this bill, allow the sponsors, both Senate and House, to figure out a good membership. I hope they expand it, but not too big so that it's unwieldy, but we endorse it wholeheartedly. Thank you.
All right. Good afternoon. Good afternoon, folks. My name is Adrian Muldrow. I want to say hello to all of the committee here and all of the folks who get up every day and represent the folks in Maryland, in addition to thanking Delegate Jazz for this great bill. Again, my name is Adrian Muldrow, and I represent TAME. TAME is a 501c3 in Baltimore. And a part of what we do is advocate. I used to be the vice president of Baltimore chapter NAACP and youth advisor for the NAACP. And I'm also an author. I bought a book. I want to gift somebody one of my books today. My book is entitled Excuse of Circumstance, but not about that. It's about, this bill as a workshop and, and the current role in the state agencies and the role that they play in reentry of formerly incarcerated folks. And the idea is to report its findings and recommendations regarding policy change. And I totally support that. I remember hearing something Tupac said, that we ain't meant to survive and it's a setup, right? But applying to this exhibit I saw at the National African American Heritage Museum at the exhibit in D.C. But anyway, we concur and we support this bill because as an ex-offender, I've been impacted in so many different ways, even after successful completion of probation. I've been and still impacted even by the state of Maryland. So, my thing is I think that, we can build a much more equitable system when things aren't convoluted, and in the study we can unconvolute things and pull things together, if you will, to save taxpayers money. 'Cause at the end of the day, that's what it's all about, making sure that dollars are spent properly and that folks are treated equitable, and also to see if this could possibly take us to where some, ex-offenders can be a protected class. So, to a certain degree, that's my stand. Thank you.
Let's do a little bit of slide up here. Members of the committee, Mr. Vice Chair, thank you very much. My name is Marty Schwartz. I'm the president of Vehicles for Change. We're a 501c3 here in Maryland. Vehicles for Change over the past 7 years has trained and placed more than 200 individuals as auto technicians. The majority of those individuals were recently released from incarceration. Our program has a 95% placement rate and less than a 5% recidivism rate. There are more than 3,000 individuals who return from incarceration each year in the state of Maryland. More than 1,300 of those will go back to prison within the first 3 years of release, the majority of those within the first 4 months of release. This work group will help identify best practices to assure individuals have the greatest chance to succeed upon release, ultimately providing opportunities to one of our most vulnerable populations, reduce the astronomical cost of incarceration, reduce crime in our state and city, and increase the overall workforce. If passed, this bill could have tremendous impact for the men and women returning from prison and our state as a whole. Vehicles for Change, therefore, asks for a favorable vote on this bill, and we would be happy to serve as a member of the committee. Thank you.
Delegate Bartlett.
Thank you. Thank you, Mr. Chair, and thank you, Mr. Majority Whip, for bringing this bill. I have to say, I'm looking at the testimony. Who doesn't want to be a part of the study? I mean, I don't mean that I mean that in jest, but I kind of don't mean it in jest, because, I mean, we've got the Attorney General wants to be a part of it. We've got the chiefs and sheriffs want to have a representative. Is there also going to be, and it probably is, and I just probably overlooked it, members of the returning citizens would be a part of the program? I'm pretty sure, but could you just highlight that just a little bit?
So when the bill is introduced, it didn't expressly state that, and that was just really an oversight of timing. When we had the event in October, we both told each other that we were going to do this, and then January came around, and we hadn't put something together. So we quickly put together the bill to send it in, but it was always our intent to make sure those impacted folks who served time and have come home, so that we can hear directly from them, as well as from the voices of organizations, like Mars, the Defense Council, those who are working with them, so that be at the table. Also, even though Adrian forgot to state it, TAME intends to be on the work group as well. But yes, we intend to add folks to it, because we want to take a comprehensive review, and we want to, I'll give an example. We passed the Juvenile Restoration Act. We have, so far, I believe 50 people have had their reviews before a judge for their opportunity to come home. Those were minors who were sentenced really long. About 30 of them have been released so far, 29 men and 1 woman. And about half of them told me that they were required as coming home to go through substance abuse treatment program. These are folks, all of them had no substance abuse issue, having been incarcerated for like 30 years. So these are some of the things that, not that those programs aren't helpful to those who need it, right? But we need to be making sure that as we are talking about reentry, we're tailoring programs, that we're also not wasting people's time. Because now, you're required to go to a substance abuse program. You may not need it, but if you don't make it to this program you don't need, you could be possibly incarcerated again. What is the point of that, right? So thank you.
Right. If I may, Mr. Chair, just 2 quick, one more group I'd like to recommend that you include would be someone from Disability Rights Maryland, or someone from the disability community, I think would be very helpful, that has a nexus with, the correctional services. And then last, I'd also like to just make one more request. If the study would also look into, and this is probably going too deep in the weeds, but what I've heard is that when people are released, they get, X amount of funds and a bus ticket, or shown where the closest bus route is. If they could look into, transportation and true transportation means, and true means of returning into society, which is what obviously the bill is going to do, or the work group is going to do. So I appreciate your work on this, and isn't that so?
I'll allow Adrian to respond to the question on people, what you are provided or not provided once you return home, if he wants to answer that.
Indeed. It's funny, I've dealt with so many different folks who've come home and had absolutely nothing. You mentioned a certain amount of dollars. If you have money in your account, they do provide, I believe, $25 and a bus ticket if you're in Hagerstown. I got that when I was released from Hagerstown, but that's not enough money. Some folks don't have the wraparound support to be able to immediately get home and have the systems or support in place to hit the ground running. So those kind of things are things that should be looked at, because just like you said, when you looking at coming home, Delegate Jazz said it in the beginning. Reentry should be looked at from the day of arrest, because those folks have to come home. If they don't have a life sentence, the folks that we incarcerate, they have to come home, and we have to deal with them. So, so anything other than equity, in my opinion, if you punish a person after they've done their time, if they're punished in any way, implicitly or anything like that, in my opinion, I think it's cruel and unusual. Because, those folks deserve the opportunity for fairness, right? Just like anybody else. So.
Thank you.
Thank you, Mr. Chair. Thank you so much for this bill. I hate to say that I've known way too many people who've gone in and not been successful coming out. But I start by asking this question because most of the people that I've known have been young people who went in when they were teens and came out when they were adults. So they missed a lot in between. So I'm asking you, will this group take those differences into consideration? Those people who went in as adults and come out as adults versus, because there are differences, those who go in as youth, our youth, but come out as adults. So there are just so many different things that they've missed and different kinds of experiences while they're in. So I would hope that there would be groups and conversations working with them that would take those things into consideration. Just as you mentioned, everybody comes out, you get a drug session, but not everybody was doing drugs, in the drug, going in or coming out. Just to take those things in consideration. And Delegate Bartlett pointed out those with disabilities, and that would be physical and learning disabilities, emotional disabilities, that regardless of the ages or what they did while they're in, coming out, they are going to have to be reacclimated in a very different way. So those are things that cut very deep and go deeper. So will those things be considered, or can they be, please?
So first I will start by saying that the chair of this committee led a multi-year approach on reviewing the needs for juveniles as well. But I absolutely do believe that many of those issues will come up in the work group. Yeah. Thank you, Delegate.
Delegate Young. Thank you, Mr. Chair. Real quick, Mr. Whip, and thank you for bringing this bill. For the brother from Tame, want to connect with you. You said you're in Baltimore, want to connect. But my question for you, and we've had a few questions about like this topics, and I know the bill doesn't speak to that, the specific topics that the work group will work on. Would it be helpful if we, kind of gave some guidance on specific things that could be talked about just to make sure that they are covered as well? Like an amendment.
Was that for me or for?
No, the initial comment was for Tame, but the question is for the whip.
Absolutely open to the will of the body. Like I stated earlier, we were under the clock to make sure we got this in on time, but we plan to take a very expansive view. We've been working on prison reform in different components over the last couple of years. Instead of continuing to do everything piecemeal, we wanted to kind of put together a comprehensive approach for where we are now, as opposed to where we were in 2015 when we did the Justice Reinvestment, or where we were in 2021 when we did the Juvenile Restoration Act or other things. So, yes, we will be open to any legislative intent from you guys.
Thank you, Mr. Whip. No questions, Mr. Chair.
Delegate Conaway. Thank you, Mr. Chair. Thank you, Delegate, for bringing the bill, and panel for coming in and testify. To the gentleman from Tame, while you were preparing to come back out, were you taught the collateral consequences of criminal conviction? Were you taught anything like that?
No, indeed. It's funny that you mentioned that, because I remember one time years ago when I was convicted as a juvenile, charged as an adult, there was a program called Junction Bridge. This was before the crime bill, and I talk about the crime bill in my book. And unfortunately, the public, it needed, but just wanted to throw that out there. But the bottom line is no, I wasn't. And those kind of things, those kind of social skill type of programs are needed.
Let me ask you this.
Yes,
Would it, since you are aware of that type of instruction, do you think it would be more beneficial if you were taught that before you got into trouble? Or you think the time to teach that would be once a person's incarcerated?
I think both. Because just like now, I hear some legislation that's out now about service. But I mean, when you're talking about education, I think it starts early. And re-education never stops. I mean, as an adult, I consider myself a lifetime learner.
Okay,
So,
that's good. Thank you.
Delegate Tomlinson.
Thank you. I appreciate it. I do like this bill. And it's great seeing Vehicles for Change here. I've been out to your organization before. You guys do good things. My question is, would you welcome somebody from the minority party to serve on this work group?
No.
Well, you will find that the presiding officers above my pay grade dictate, so I'm not going to get too big for my britches. But I will state that I am very encouraged by the wide support we're seeing from folks who want to participate, from Vehicles for Change to the Defense Bar, and to a lot of it directly impacted people and other advocates. I think having those voices will lead to better findings and recommendations that we will then come back to you guys to figure out what we can actually do and what resources are available. I'm sure the next question many of you all will have are the type of resources that will be needed to help these folks. I think some of that is referenced in the fiscal note on how the prison population decreased from the Justice Reinvestment Act, and there's some money in a fund there. You know, I don't want to get ahead of ourselves, but just saying that, of course, funding will be required. But first, we need to figure out how to coordinate across state government the needs. And I just really appreciate the partnership from everyone who's here and those who've written testimony so that we can get this right.
Thank you, Delegate Lewis.
Thank you, Mr. Chair. Thank you, Delegate and the panel. I, too, am very well looking forward to this as well. I do have a question as to two entities that are absent from your work group, and I don't know what their interest is or how they've reached out to you. But I don't see the Department of Public Safety and Correctional Services or Parole and Probation, and I would be wondering if their input, if they've expressed input, and just for successful reentry, they would be integral components.
They absolutely need to be part of the conversation.
I didn't know if they had reached out to you as well.
They had not reached out. We have had a lot of conversations over many years. So I think they've appreciated not having too many calls from me as of late. But they would absolutely need to be part of the conversation.
Thank you.
Seeing no further questions, that concludes this panel.
Thank
we
you
have
all.
people who are signed up to testify favorable with amendments. We're going to hear from them now, including Grayson Wiggins and Kevin Kennelly. We'll have those two people come up to the table, and then Kim Haven is now gone. All right. Sometimes she pops up anyway, so let me know, and that'll be fine. And we can hear from Mr. Wiggins to begin, please, for 2 minutes.
Thank you, Mr. Chair, members of the committee. For the record, Grayson Wiggins here today on behalf of Employ Prince George's, which is the fiscal and administrative agent for the local workforce development board in Prince George's County. We like the bill a lot. We like it so much that, as other people mentioned, we'd like to be a part of it. So Employ Prince George's provides services, workforce development services and training programs and connections to employment for more than 20,000 people in Prince George's County annually. Our amendment would add one representative from a local workforce development board. If you don't know what a local workforce development board is, you probably have one in your area that provides workforce development services. MOED is an example in Baltimore City. It's the Mayor's Office of Employment Development. And so what these organizations do is they're federally codified under the Workforce Innovation and Opportunity Act, and they provide workforce development services across the state to people in the specific regions. They're actually included in state law as well, and they receive federal, state, and local funding. And so when we talk about reentry
I think a critical component of that is workforce development, connecting people to sustainable employment and careers that keep them or help transition back from reentry. And so with that, we just ask to be included, and we thank the sponsor for bringing the bill. Thank you, Mr. Chair.
Good afternoon, Mr. Chairman, members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of the bill with an amendment to add a representative of local corrections to this work group. We often see that counties have informal agreements with the state when individuals are released from state facilities. They can bring them back to a county facility right before they get released, and that may have access then to family, friends, resources in the area, and I think that's a really good outcome. We also have a number of counties and local corrections folks who work very hard on these reentry programs. They make sure that people have access to wraparound services, services provided by local health departments, transportation, et cetera. So we think they'd be a valuable asset in addition to this work group, and we'd appreciate the committee in its wisdom making them a part of the work group. And with that, we'd ask for a favorable report with that amendment.
Any questions for this panel? Seeing none, we thank you very much. That'll conclude the testimony on House Bill 661. We're going to Delegate Cardin now on House Bill 663, and we'll have Mike Davey, Ari Plout, Frank Boston join him up front.
It's just Mr. Plout and Mr. Davies.
That's fine. I see Mr. Spencer, but not now, because you're an informational testifier, and we have one person testifying unfavorable. Delegate Cardin for 3 minutes.
Thank you very much, Mr. Chair, members of the committee. Again, John Cardin on behalf of 663, asking for your favorable report on it. This bill is about transparency, clarity, predictability, and oversight. I was one of the people who proudly supported police reform a few years ago. However, we need to make sure that as we move into this world where we're making sure we're trying to protect everyone in our community, that we do it in a way that's predictable and gives everybody a degree of transparency in what they can expect. This bill, it basically authorizes law enforcement officer who has been administratively charged by an administrative charging committee or law enforcement agency to file a petition to show cause in the circuit court so that they can learn a little bit about what's happening in their situation. I'm going to let the experts talk about it. I will indicate that there is some unfavorable testimony from the judiciary, and if you will note, they're not opposed to what we're trying to accomplish here. They're opposed to some of the language that requires it to happen in Anne Arundel County versus the specific jurisdiction. Maybe we can fix that if we decide that this is the right way to go.
Mr. Chairman, Mr. Vice Chairman, honorable committee members, my name is Ari Plout, and I'm here on behalf of the Maryland State Fraternal Order Police in strong support of House Bill 663. Thanks, Delegate Cardin, for sponsoring this bill. And I won't get into what it does. Ms. Delegate Cardin just spoke about it. I'll let Mr. Davey when he speaks. But just this bill is strictly for judicial economy, and we ask for your support and ask for a favorable report. And with that, I'll turn it over to Mr. Davey to further elaborate about it. Thank you for your time.
Good afternoon, Mr. Chairman and members of the committee. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we're requesting a favorable report on House Bill 663. As you know, the Police Accountability Act was created, took effect in 2020, actually passed in 2021 and didn't become effective until July of 2022. House Bill 663 would authorize a law enforcement officer to file a petition to show cause in the circuit court prior to a trial board to order the law enforcement agency to show cause why a right under the Police Accountability Act was not afforded to that police officer. Basically, the bill would give the law enforcement officer the right to have a circuit court judge rule on a violation or a possible violation of a right under the Police Accountability Act prior to the trial. It basically works like this. If an officer believes that one of his rights were violated after we receive the investigative casebook, he can file a petition with the circuit court. And in the bill, we put in there the same locations as if it were an appeal. A statewide agency would have to go to Anne Arundel County. Any other jurisdiction would go to their local circuit court in their jurisdiction. That's why we've made it that way. The law enforcement officer files that petition. A circuit court judge looks at it. If he doesn't find any merit on its face, it's dismissed and we move forward with the trial board. If he does find merit, he then sends a order to the law enforcement agency to document why the right was not violated. There's a hearing. The judge makes a determination as to whether there was a violation or not, and the judge then gives the equitable remedy based on the violation, if that does in fact happen. Again, the passage of this bill will ensure judicial economy. The circuit, I already went through that. The petition itself does not automatically stay the trial board process. From our former law enforcement officers' Bill of Rights, where there was a show cause, there already is case law on that, and it's Mass Transit Administration versus Hayden. In that case, the court ruled that a trial board does not have to stay or the law enforcement agency does not have to stay the trial board, but by proceeding prior to a ruling by the court, the law enforcement agency risks the court vacating an administrative decision and possibly having to hold the trial board again. So it doesn't automatically delay this process. It doesn't automatically stay this process. It just gives a circuit court judge the ability to make a decision. Our hope is if we can get this done out front, it will be one less appeal issue, if any, on the back end. I've been doing this for 25 years. Under the LEOBR, in 25 years, I filed 7. That's it. This is not something that's going to clog up the courts. This isn't something that's going to be overwhelming through the judicial system. But there are cases, and especially with the Police Accountability Act being in its infancy, we have concerns already as to how some agencies are treating certain issues.
Thank you, Mr. Chair. You weren't here when police reform was, I mean, I wasn't here, but you were, Delegate. And I think that one of the main goals, because I was a live stream groupie, if you will, and I listened to it, was for prompt accountability for police officer and greater accountability. And I just don't see how your bill enlightened me, because I don't see how it doesn't delay accountability and put more hurdles in place for adjudication and final disposition of cases.
So, Mr. Davies will respond to that. Yeah.
Thank you. As I stated, there's already case law that I believe will be consistent and still be followed, that it doesn't automatically stay. The judge could stay it if he wanted to, the circuit court judge reviewing the show cause, but it's not an automatic stay, and there's case law that's already on the books that indicates that departments or the law enforcement agencies can go forward, but it might be at their peril.
Thank you very much.
And you were that one groupie on my blog. I tried to figure out who that person was.
Colleagues, I know I'm hot and heavy today, so I apologize. Real quick, can you just explain, like, all of the different places where this could go into effect? Like, what are all the different places where, you know?
I'm glad you asked that, because I kind of took some notes preparing where this might occur. So one of them might be a statute of limitations issue under the Maryland Police Accountability Act, Public Safety 3105C1, talks about what the Administrative Charging Committee is required to do and when an officer has to be charged within a year and a day if it's a complaint from the public. What happens if it's after? What happens if they charge them 8 months after the 1 year and 1 day? We would like to be able to go to a circuit court judge and get it dismissed, if possible, before we have to go through the process of a trial board. Another section in this, and we're seeing it in some of the larger departments, is some departments are taking a different position than what I believe the law is as to what cases go to the Administrative Charging Committee and which are handled internally by the police department. The law says it's a complaint by the public, but I've already heard from some agencies that, well, yeah, it's a complaint from the public, but we would have made that complaint too. So therefore, we're going to handle it internally and not take it to the ACC. And that's not what the law says. And another one was, an allegation of when the incident actually occurred, believe it or not. The law basically says that if an incident happened before July of 2022, the case stays under the old Law Enforcement Officers Bill of Rights. If the incident happened after July of 22, it goes under the Maryland Police Accountability Act. Some agencies are already playing with that in that, well, the incident might have happened prior to July of 22, but we didn't get the complaint until July 3rd of 2022. So we're going to now push that into the MPA as opposed to the old LEOBR, which we're still dealing with. And, you know, we've been in this position now since July of 2022. I represent probably 90% of the law enforcement agencies in the state doing trial board work, and I have not seen one case as of yet come out of an ACC.
Last question, Mr. Chair. Would you be open to any type of language to guard against frivolous use of this type of effort?
I don't know how you would write that, but as an attorney who's handling these kind of cases, or any attorney, they have an ethical duty not to waste the court's time and bring frivolous complaints, and they can be sanctioned if they in fact do that. I don't know how you could craft language into that, but there are already points on the professional responsibility of an attorney.
Thank you, Mr. Chair.
All right. That appears to be questions here. Thank you very much.
Thank you,
We'll
sir.
have
Thank
now
you.
for informational testimony from the chiefs and sheriffs, please. Sorry. Oh, I thought all right. I'm sorry. Yes, we have informational testimony, and I looked at the wrong folder. That doesn't help. Jerome Spencer, go ahead.
Good afternoon, Mr. Chair, members of the committee. My name is Jerome Spencer. I'm here on behalf of the Maryland Chiefs and Sheriffs Association. In my day job, I'm the General Counsel of the Charles County Sheriff's Office, and I handle disciplinary matters as part of my duties. We want to make you aware of some of the things that would come with House Bill 663. First, we make it very clear that chiefs and sheriffs absolutely 100% support due process right for officers. We want to make sure officers' rights are protected at all steps of the proceeding. That being said, House Bill 663 reinstates part of the LEOBR that is different than normal process for administrative reviews. Typically, if you have administrative hearing, you complain to the administrative hearing board, the trial board, resolve the issue. If you don't resolve the issue, it goes to appeal. This reinstates something that's out of the normal for administrative procedure. And I heard Ms. Davis say this won't delay proceedings, and yet it must. By definition, will delay proceedings. You have to get a circuit court judge to hear the show cause petition, get the circuit court hearing, and there's appeals from that. Give about one example, this case from about a decade ago, Popkin versus Gindelsberger, where it took over 2 years for the show cause to get resolved. And frankly, that's incredibly fast to go from circuit court to court appeals within 2 years. Now, Mr. Davis suggested that the hearing board does not need to be stayed, but he also told you what the case law said. If the agency goes forward, the trial board, it does so at its own risk. No agency would ever go for the trial board for the show cause pending. I would not advise my agency to do that. So it delays the proceeding. Finally, it should note that the bill allows the officer to require the agency to show cause, and yet some of the issues that Mr. David talked about don't necessarily involve the agency. The agency has no control over the Administrative Charges Committee. We can't make the ACC do a report in 30 days. We can't make them give them their charges within a year and a day. And yet the agency is directed to show cause for something the officer is going to complain about. As Mr. Davis said, House Bill 670 presented us with a lot of challenges. We're working through those challenges. We're very early in the process. I think it's too early to say that these issues are going to be an issue, and if they are, perhaps it can be resolved through the trial board process. Thank you.
Questions? Seeing none, thank you very much. We had one person signed up in opposition. Mr. McAvoy is not in the system, so that concludes the testimony here on House Bill 663. We'll go down to Delegate Hill for 2 bills. House Bill 774, please. Kevin Canale and Meredith Weisel.
Good afternoon, Mr. Chairman. I guess I would say good afternoon to your vice chair, but they're not here. So I'll say good afternoon to the members. Okay. You're hanging in there alone. So for the record. I'm Terry Hill, and I'm here to present 2 bills, HB 744 and HB 745. These bills deal with similar issues and were previously introduced as a work product of the Next Generation 911 Commission, but has also been introduced in various forms by other interest groups, such that at the end of last year's session, the decision was made by judicial proceedings in this committee to put a work group together to look at these issues that are addressed in these two bills in a very deliberate fashion and try to come up with a comprehensive solution that addresses the seriousness of the offenses and also it does not go overboard in terms of the punishment. Delegates Bartlett, Lopez, and Munoz were part of that work group, and I'm presenting because, as I said, it came out, at least in part, from the Next Generation 911 Commission, of which I was a member. Okay, so what are we talking about here? We're talking about three things known as swatting, TDOS, and DDoS. Right? Swatting is when, essentially folks go out of their way to represent to emergency services, receiving personnel, 911 operators, law enforcement, lies designed to get them to send out the SWAT team and target someone who is innocent. It can be very exciting. It can also be very dangerous. So that's 745, which I'll talk about in a second. 744 deals with the two other areas, TDOS, or telephone denial of service, and DDoS, distributed denial of service. TDoS is where a large volume of malicious calls are made for the purpose of disrupting the service. So if a bot or an organized group of people decide to call 911 to the point that 911 can't answer other legitimate calls or it takes the service down, that would be a TDoS attack. If they're using other kinds of electronic means to take that PSAP down, or it doesn't have to be related to law enforcement, but take down any computerized system and stop it from functioning the way it's supposed to, that's a DDoS attack. And what we're trying to do in 744 is to make it clear that these are serious offenses, and we're going to treat them seriously. So that's the purpose, and what 744 does is enhances that when you're targeting it enhances current laws by saying that if you're targeting a PSAP, this is a much more serious offense, and we're going to treat it as such with enhanced penalties, with imprisonment up to 5 years and a maximum fine of $25,000. If there's an attempt at disruption, and if it's a successful disruption, then the penalty is imprisonment for up to 10 years and up to a $50,000 fine. So that's 744. Thank you.
Very
Thanks
much.
for the extra time.
Please go ahead.
Thank you, Mr. Chairman, members of the committee. For the record, Meredith Weisel here representing ADL, the Anti-Defamation League, and I also served as chair of the task force. The task force report was sent early, wasn't due till June 1st of 2023, but we did send it to the governor, to the Speaker of the House, and the Senate President just a few weeks ago, and from that came out these two bills. The issue of swatting is one that the Anti-Defamation League, as a leading anti-hate organization, has been looking at a national level and taking a look at different state laws to see if they're keeping pace with the issue of swatting. As online hate, and we do consider this in the category of online hate, as online hate and harassment has continued to increase, we are seeing things like doxing and swatting and non-consensual pornography and several other issues related to this. Swatting has become a very serious issue. Both of these bills, House Bill 744 and 745, address different aspects of it. 744 specifically, when a swatting incident has happened, as Delegate Hill and her leadership have talked about, it can tie up the 911 system, and somebody who is having a major emergency may not get the services they need because the services that are supposed to be helping them are being tied up. On 745, which I know is the next bill on the list specifically, I'm happy to go into more details. That is specifically taking a look at the issue of the criminal statutes. We have a couple of laws on the books, but they don't go far enough, and they are very minor compared to what we're looking at. And the task force really went at great lengths, and I'm very grateful to all the delegates and senators that served on this, to look at current laws, to look at a lot of the other state laws, and to come up with a comprehensive approach, and also taking into account juveniles, and when it is a first offense, and when it is something that leads to more serious bodily harm. So with this, we ask for a favorable report. Thank you.
Good afternoon, Mr. Chairman, members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of House Bill 744. As Delegate Hill mentioned, she was a very integral part of the Next Generation 911 Commission. MACO, through a legislative initiative in 2018, passed a bill, got a bill passed to establish that commission, and it's done great work. These two bills are very, very important for public safety and for at large, right? So TDOS and DDoS, the whole intent there is to disrupt a 911 center. You can imagine the repercussions from that. People can't get through that have emergencies. It creates a whole host of problems, and we know that these incidents can cause bodily harm, and they can cause great, great harm to our communities. And when it comes to swatting, I mean, this started as a video game culture kind of thing. It has evolved over the years, and it's obviously very dangerous. You send somebody, you send the SWAT teams to someone's house, that ties up law enforcement resources. It costs a lot of money, but it's also very, very dangerous for the person who is being swatted, for the law enforcement response, and then also for the community at large who may be adjacent to this incident. So these are very, very important bills. We're in strong support, and we'd urge a favorable report for both. Thank you.
Are there questions for the panel? Delegate Boucher.
Thank you, Chairman, and thank you, Delegate Hill. Are there cases and incidents where a criminal element would flood a 911 board to perpetrate a secondary crime like rob a bank? That does happen?
Absolutely.
All right, thank you.
Delegate Cardin.
Thank you very much, Delegate Hill, for bringing the bills. So right now, these types of offenses are considered a misdemeanor with a $5,000 maximum or a $2,500 maximum and a 5-year penalty.
Well, correct. And I actually talked, the penalties I discussed in the bill were for 744. They're a little different for 745.
Okay.
But yes, they're treated as a slap on the wrist.
So it's an increase in penalties
across the board.
Is a vast portion of this. Just curious about like first-time offenders who may be a computer whiz who makes a mistake as a teenager, thinking it's really cool to do something and doesn't. So you said that you tried to get into your task force an ability to make sure that these people don't get the book thrown at them. Can you just
Yeah, and that is, yes, thank you, Delegate. That has been talked about nationwide, looking at that, and Maryland in particular, we know, has been very careful with juvenile justice reform and making sure, when it is a minor. However, when you look at the way the bill is drafted, it also takes, there's first offender, but also takes into account whether or not the swatting incident caused bodily harm, death, reckless disregard. It's not just a prank. We'd have the facts, obviously, we'd have to look at the individual facts of the case, but we really did have a lot of discussions. I know Delegate Bartlett and Delegate Munoz could also speak to some of that, but that was a lot of the discussion to make sure that the harsh penalties, particularly for a first-time offender, because we certainly are seeing that happening. Most of these, though, it is very intentional, and that was the conversation that we talked about, the intent of it, and that's where you have to look at the facts, and the prosecutors can look and see what was the intent that they were trying to cause. And this body actually also passed a bill related to when it's motivated by hate and bias, and that also carries higher penalties now, because that has been where some of this has been motivated by as well. Thank you.
Specifically, Delegate Cardin, if it's a first-time juvenile offense on the swatting, it stays juvenile. Yeah. So that's the first big piece. The procedures and dispositions follow juvenile offenses. They cannot be committed to the Department of Juvenile Service for out-of-home placement. So it can't result in those kinds of extreme responses.
Okay. And, a 19-year-old who I used to think that a 19-year-old was an adult. Now, as I get older, I think that 19-year-olds, and if it's a first-time offense for them, are there some protections there? It's an intent-based crime.
An intent comes into play, and the penalties are up to. They're not mandatory minimums. They're up to. So the judge and also the prosecutor has discretion in terms of what's recommended and what's actually.
Thank you, Mr. Chair.
Just to be clear, there's nothing in here that says, there's nothing in 744 that says that there can't be out-of-home placement for a juvenile.
Correct. It's in 745.
Oh, it's in 745. Okay, coming attractions then. All right. Any further questions on 744? Okay, thank you very much for that. I don't think there's anybody speaking in opposition to that. There are not. So we'll go now to 745. Same people, I think. Yep. All right, let's start all over again. Delegate Hill.
Well, let's not start over again. Let me just add to and show the distinction. So under 745, the primary violation penalties are that violators are guilty of a misdemeanor punishable by imprisonment for up to 3 years or a fine of $2,000 if the report is proximate to a physical injury or severe emotional distress, a death. They're guilty of a felony. And at that point, it's 10 years or up to $20,000. The violator can be civilly liable for the damages. So if you're swatted and the police break down your door, the person who caused the swatting may have to pay for those damages. Okay? And that's when we talk about the distinction for the juvenile offenders that I just mentioned, that they cannot be reprimanded for out-of-home placement if the false report is the most serious thing that they did. Right? And again, intentionality is an important part of the determination of the punishment.
Any questions for the panel before I ask one? Delegate Munoz.
Thank you, Mr. Chair. Thank you all for coming today to give us such a thorough understanding of what these two bills do. Would you mind speaking a little bit on why the second one in particular is necessary and the risks involving death, and also the trauma that children have experienced when they're in the home and a SWAT team enters?
Yeah, sure, I'm happy to. Thank you. So I'm going to answer it this way. So when we have been looking at reports of online hate and harassment, and again, as I said, this includes something related to swatting as well, we have seen severe harassment, we have seen physical threats, we have seen sustained harassment, stalking, swatting, all of this. And what we are seeing is that more than 20% of Americans have faced this, and it causes severe emotional distress, to your question. And some of the examples, and we will make sure the committee gets a copy of the task force report, if Mr. Chairman, if it has not been sent to you yet, because it goes through some of the examples that we have seen. And there are times where a SWAT team is called out because it's a false report and it's not just a prank. And there are children who have witnessed their parents be handcuffed for something that they had absolutely nothing to do. They are breaking down doors because they believe somebody is being held hostage or being held by gunpoint and stuff. And it is having this severe impact on the mental health as well as children in the community, but also just the emotional distress on the individual who has now faced something that they had nothing to do with. And we are also seeing marginalized communities targeted more and more through this nationwide. We are certainly seeing calls come in from other states or even internationally. What we are trying to obviously capture here is having, each state look at it. And so when it is happening within the state, those individuals can be held accountable.
And just by way of follow-up, so when we're talking about the risk of death and why, this level of research and this work group was necessary, and all the experts that were part of it. So we're talking about when a SWAT team enters a home where no one has done anything wrong, people are not expecting it.
Right.
If people in that home have firearms and they don't know what's happening, they could pull those. And so then there's a risk to both the people living in the home as well as law enforcement.
Right.
And we've seen deaths occur.
And let me just add, and you bring up an excellent point, Delegate Munoz, which is that, first of all, the person who's swatting is going about their business. And the call is typically going to be, you know, we have reason to believe that they're being held by gunpoint, they're not going to be able to come to the door, right? Wolf Blitzer, the CNN news reporter, is probably the most famous recent case here in Maryland of someone who was swatted, okay? He was not even home, all right? But the police came, they scouted, didn't see anything going on, were very concerned that there was something going on in the house, and I'm trying to think, I think his wife came to the door, just happened to, and that's the only reason they didn't burst in. But you're correct. Door gets knocked down. We see it all the time, whether it's Breonna Taylor and people think they have a legitimate excuse or not. But when you don't have a legitimate excuse and the police show up or they show up at the wrong door, that's one thing. But when they show up at the door that someone deliberately sent them to for the purpose of having them show up to mess with the people inside, disregarding the potential danger to the people inside, it's not a joke. Disregarding the fact that the police officers can get hurt, disregarding the fact that on their way to what is an urgent event, they can have accidents and damage other people along the way. It's a significant problem. And our little $5,000 slap on the hand doesn't treat it like a significant problem. And not having people civilly liable for the damage that occurs does not treat it like it's a significant problem. It's not a joke.
Can I just add one more thing? Just another example, specifically in Maryland. In 2015, I was just looking at my notes, somebody was seeking revenge against an individual named Tyron Dobbs. They falsely claimed that he was holding 3 hostages at a home in Howard County, Maryland. And the police responded. They had to evacuate the entire apartment building. And after speaking with the negotiator, the individual, Tyron Dobbs, who was swatted against, he came out to the door and he didn't hold his hands up, and they powered him with rubber bullets, knocked him in the torso, knocked him down, and he was severely injured because of that. So him plus everybody in the apartment building had to be evacuated. And this was a completely false statement that somebody had made, well, more than a statement that was made.
Seeing no further questions, that concludes the testimony on House Bill 745. Thank you both very much. All right, Delegate Grossman is here, and we'll hear from her on House Bill 667. She's going to testify, and then we'll have other people testifying. So Delegate Grossman for 3 minutes, please. Go ahead.
Okay, great. Thank you. Mr. Chair, Mr. Vice Chair, and members of the Judiciary Committee. For the record, I'm Delegate Brooke Grossman, and I'm here to present HB 667, Overdose and Public Prohibition for your consideration. The purpose of this bill would be to add public overdose to the Disturbing of the Peace Ordinance. This ordinance currently carries a penalty of a $500 fine and 60 days in jail. HB 667 adds the referral to drug court or local outpatient treatment program for communities that do not have an established drug court for overdose offenders that are charged with under this Disturbing of the Peace provision. This bill does not seek to criminalize addicted individuals or to instill in them fear of seeking help. The goal of this bill is to path individuals towards needed outpatient treatment. Across the state, we have an inequity in rapid access to substance abuse treatment. This leads to individuals seeking treatment and landing and at times remaining on wait lists for help, while at the same time continuing to fight their battle in the community. At times, this results in individuals using narcotics in public places, like local businesses, our libraries, and sometimes even the streets in front of our citizens' homes. In my community, our local library has reported no less than 7 overdoses at their location in the past 12 months. In many of these situations, library employees were the first to respond, calling emergency responders, traumatizing staff and contributing to burnout. My hope is for this bill to serve only as a tool in what becomes Maryland's robust toolbox to serve those with substance abuse disorders and accessing treatment. This bill is not to replace services like peer recovery, harm reduction, street outreach, or other community-based services, nor is it meant to discredit their value. It's only to add a resource. My goal is to work collaboratively with both the law enforcement, EMS, and recovery community to create a response that balances the needs of both individuals with substance use disorder and members of the community like the library workers above. Drug courts are collaborative efforts between our court system, substance abuse treatment, mental health case management, workforce development, peer support, and housing providers to offer comprehensive wraparound supports, not only addressing the substance abuse disorder, but also providing necessary supports beyond sobriety. According to research, there's evidence that drug courts are effective in preventing future use. Drug court participants have lower rate of use after completion and shorter periods of inpatient treatment in case of relapse. Thank you for your consideration, and I'm happy to answer any questions.
There we go. Thank you so much for coming in, Delegate, and bringing this bill. So I'm just looking through it here, and I definitely hear this is a problem. It's, I'm sure, very scary for the library employees. I'm just trying to make sure I understand. So this would put them in a situation where they're going to get sort of a court-ordered treatment plan.
Right. So what we're hoping for is you're at the library, 911 has to be called, right? That in your court appearance, they would lead with a referral to treatment. Most of our counties in the state of Maryland have drug court, so a drug court referral, and those that don't, their local IOP provider. It's certainly just like a drug court referral now, the choice of the person when they get there, whether they would accept that treatment or whatever the fine of the charge would be.
Okay, so there's no fine in here that I see. So I don't see that there's really much of an alternative. It's I see it down here. Okay, 60 days or $500. Is that what you're thinking? Imprisonment up to 60 days or $500?
That it's and or.
Okay.
Right, that's how it's written as a disturbing of the peace now. So this is just adding this particular behavior to the current disturbing of the peace ordinance.
So I'm trying to think through, let's just say I was a drug user. If I wanted to avoid getting in trouble like this, I'm just not sure how I would be able to not overdose in public. Like, I don't think most drug users intend to overdose. Do you know what I mean?
No, I don't either. But I think that the behavior, right, there's a balance. They don't intend to overdose in public. But the person that went to the library today also doesn't intend to have to call 911 because someone has overdosed in the bathroom, right?
Yeah.
And we're impacting then libraries or even businesses in my community, I'm speaking for, where people are not visiting those locations anymore because this is happening frequently at those places.
I mean, yeah, this is definitely a really complex and troubling issue. I just don't know how anyone could really prevent this from happening to themselves other than just not leaving their house, essentially. If they have a drug problem, they would just not be able to leave their house.
Sure. I mean, I think the overdose in public, and if you'll see, it's the use that leads to an overdose in public, right? So they are then they're leaving home, they are taking their substance with them, and they're using it at that location. Mm-hmm. They could use it home before they leave, perhaps, right? Not use in that public location.
Yeah, I guess if they weren't operating a motor vehicle, that would maybe work. Does this exclude people who have prescriptions for their medication?
I'm sorry?
So if, let's say somebody had a prescription, but they accidentally overdosed, would they be excluded from this, or would it include them?
We haven't, that's a good question. We didn't dig that far down. I think that's certainly something that we could explore.
Okay, all right, thank you.
Mm-hmm.
Elliot Williams, Nick Conway, Simpson.
Okay. Hi, Delegate Grossman. How are you?
Hi, Delegate Williams. How are you?
Good. Is this your first time here?
Yeah, it is my first. It's not my first bill,
but
it's
first
my
time in
fourth one in the
Judiciary.
last 48 hours, though. So
Okay. Well, welcome
thank
to
you guys.
Judiciary.
Thank you.
Quick question. I'm trying to think. So Delegate Eric Hand was talking about the penalties. I think the 60 days or $500 is actually existing law. So that's what's currently in place in terms of the misdemeanor. But my question is, when you were working on this, did you talk to the Maryland Department of Health at all as you were working on this?
So
for their input?
They are not big supporters, right? And I get that, and that's why I also kind of said later in my testimony, I'm happy to have continued conversation of what we can do collaboratively to find that balance, right? I fully support people accessing treatment, and I am a big believer in the stages of change, and we know they're going to do that when they're ready. But I also, I do feel strongly that folks going to public places in our community, like our local library, also need to feel safe to do that. So
Right, and actually my uncle was a librarian, worked for 35 years for the Library of Congress, so I definitely support librarians. There was some testimony that was provided by a number of different organizations, and I don't know if you talked to any behavioral health specialists or people who work with individuals who have substance abuse disorders. But the sense that I got from just looking at all the written testimony and just from the work that has gone on over the years, from my little time of 4 years being on this committee, is that I think it's kind of going in the opposite direction in which we've been trying to go over the past couple of years in terms of decriminalizing people who have legitimate behavioral health issues. And so I guess my question is whether or not you've spoken with any of those individuals who work in this space for their input on this.
So I did, again, and they don't agree with this path.
Okay.
Right. There's certainly opposition, and I am acutely aware of that. Right. I think that, again, the spirit in which this was written was really specific to the experience that we're having in my community, where there is also significant lack of that rapid access to care that is available in larger communities, right? I am speaking specifically and candidly about knowing someone that I and another staff person of mine in my day job sat all day with getting, a treatment bed, who then was dead across the street from my house that night when I came home. And if we can find ways to path even to outpatient treatment more rapidly, that's a goal. If there are better ways to do that, I'm open to that conversation too.
No, I understand the intent, your intent behind it. I definitely applaud the intent behind it. I represent part of Prince George's County. We have a drug court program, which actually there's a waiting list. We don't have enough slots for the individuals who would need that type of service and that type of program in a large jurisdiction like mine. But yet we have individuals who have those same issues and need those services. And so I definitely applaud the intent. I just am worried about the message that it's sending. And then we're saying, okay, it's okay to overdose at home, but it's not okay to overdose in the library. It's okay to overdose in a hotel, but it's not okay to overdose while you're waiting for the bus. Like, I don't know. I just feel like it just needs a little more.
Sure.
Okay. All right, thanks.
Very quickly before I go to Delegates Conaway, Grammer, and Tomlinson, as Delegate Williams just noted, the drug court programs tend to have waiting lists, and they also tend to have some minimum standards for when you can get into a drug court program. They look at the length of the sentence that the person could be facing. So usually, at least here in Anne Arundel County, 60 days, a 60-day maximum is not something that they would consider for entry into drug court because it's too short of a sentence. Were you able to talk in your conversations with the health department and others, did you hear from drug court programs that said...
With our local drug court, we did, about adding this charge, and they certainly were open to that. I did not go beyond the scope of my community because this was something that was brought forth by my community, but we certainly should.
Okay. Delegate Conaway, then Grammer, then Tomlinson.
Thank you, Mr. Chairman. Thank you, delegates, for bringing the bill. I'm trying to understand.
Sorry, Delegate Conway?
Yes.
Since this is my first time in this committee, I'm also 80% deaf bilaterally.
Oh, I'm sorry.
Thank you. I appreciate it.
All righty. I'm trying to understand how a person goes from, let's say, overdosing in the library to getting a misdemeanor charge and a fine. How does that happen? Someone calls for an ambulance?
Right.
Okay.
Right.
And
so
then what happens?
Well, currently what happens is that an ambulance, usually a police responder, and at sometimes a supervisor also show. That individual is then, assessed on the scene. If they're able to be Narcaned and revived, they are, and then they're certainly given an option if they would like to go to the hospital for additional treatment. But if they don't want to do that right now, they're able to just leave. So all of this would result in is similar to if I am walking down the street with an open container and I am stopped and I'm given an open container citation or charge, right, then I later am expected to show up in court for that. The fiscal note, as I understand it, is related to if those individuals did not accept the referral to drug court or to treatment and chose to either have to pay the fine, which there's an administrative kind of cost of tracking that down, or the 60 days in jail, there would be a cost for housing that person during that time.
You skipped the part. Once they got the Norcan, you said then they could leave. So when do they get the citation?
So you would get,
So
again.
they wake you up after you overdose, make sure you're okay, and then say, where's your license and or positive ID? Then they give you a citation?
They would give you, right, you would be charged, you wouldn't be taken to court or to jail at the moment, no.
No, I understand. So you
No,
charged
the
with
jail would only be, should you go to court for your public disturbing of the peace charge, you showed for your court appearance, and you said, I choose not to.
So is it mandatory on this citation? Once they revive you, see that you're okay, then law enforcement is going to give you a citation for overdosing in public, right? Then you have the choice to either pay a fine, or you can go to court to challenge the fine, or how does that work? This is the first time I've heard this.
Sure. So again, for disturbing of the peace, my understanding would be you would show for your court appearance, and the judge currently would either give you a $500 fine or 60 days in jail. You wouldn't pay the fine prior to the appearance.
So it's a must appear. You must
Yes.
appear.
Yes.
Okay, and this is happening across the state. This is everybody does this. This is the way it's done.
That is how it was explained to me under current law through our state's attorney, that a disturbing of the peace requires an appearance.
Thank you very much.
Yeah.
Thank you, Mr. Chair. I have a similar problem. I represent that. Can you hear me okay?
No, your microphone's not on. Thank you. Sorry.
Let's try again. So I have similar problems at my district. I represent southeastern Baltimore County, and at the libraries we have not necessarily purely overdoses, but we certainly have a heck of a lot of drug use. So your bill does a couple things. It applies a penalty. Is that correct?
Right. So it would lead with, again, the choice of the penalty, 60 days in jail or a $500 fine, but it would say an alternative sentence to you, right, would be to participate in your local drug court if your community has that, or an outpatient treatment program that you're referred to.
So the courts can already do that. If I'm mistaken there?
Yes, just not for this particular behavior.
So if there's an overdose, they cannot refer you currently?
No.
Really?
No. Currently, if there's an overdose, there's a citation that someone is given, not a citation with a requirement to appear, just a citation. So that is the reason to ask to add this with the requirement to appear and a potential referral to treatment.
Is that based purely on the overdose, or is that based on drug use?
My understanding, it's the overdose. It's the current response to overdose is you are revived, you are given the opportunity for additional treatment. There's certainly a call potentially to peer support or to others that could come and respond if you choose to stay in the community, but there's no additional penalties to that right now.
Okay. So I know police...
1 second. If you are on the floor system on your computer, we need you to log out and then log back in. They have a fix that will help you read the written testimony and everything else. Okay. Thank you very much for your careful attention to this matter. And now back to Delegate Graham.
Thank you. So I know that police don't actually have to arrest you for this. For example, in Baltimore County, oftentimes if they know who the person is who has an addiction problem, they know the situation, and they don't always arrest them. Sometimes the police will just defer them. So is it particular to the drug use or the overdose that a court cannot refer you currently? Do you know?
I don't know the answer to that, but I can find out for you. Again, for me personally, this was brought forward at home, and our law enforcement leaders were part of that conversation because they're responding regularly to these same individuals overdosing in these locations and really wanting to have another push towards treatment that they might be able to provide to them because they can't do that now.
Okay, thank you.
Delegate Tomlinson.
Thank you, Chairman. Hi, how you doing? Good to see you. I think, so, I know you and I have talked about this bill in the past, and could you just clarify, and I think I know what the intent here is, it's definitely not to criminalize, definitely not to get anybody in trouble, but can you just help give a little bit more explanation on why this bill is important and how it will lead to getting people help?
Sure. And so that's all contextual, right?
Yeah.
Because, to Delegate Conway's question, people have to show up to court to get that referral, right? But if you're catching people at the time when something like this happens, and perhaps there is just the motivation behind a citation that says you have to appear versus one that is a piece of paper, right, that you don't have to appear. And then you stand in front of someone who says, I don't want to punish you for this, I want to offer you treatment, right? And I want to path you in that direction. That's my hope, right? That's my goal of this. To Delegate Williams' questions earlier, so I understand the kind of evidence that there is that you can't force people to get better, and I agree with that, right? But I do also think, as I shared before, that there's a balance in that for our communities, right? There are the people that are being directly impacted by their substance use, and then there are people around them that are being indirectly impacted who also have to feel, right, that their considerations are being put forth as well. Does that answer your question?
Yeah, and I think, I know, and I go back and forth on that I think it's a pretty well-known thing that addicts, addicts need to want to, they need to want to help, to be helped. But I think what you're trying to do is just give that kind of extra nudge.
Sure, and I think that it's important to highlight that when someone is addicted and they are not seeking treatment, it's not because they don't want to be well, right? It's just maybe they're not in a place where their mind is able to take that step, right? I'm not suggesting that addicts want this to happen to them. I'm just suggesting that maybe there's a nudge or a carrot that we could put behind it that would motivate them, right, towards an outpatient treatment program that could be the start of getting better. Does that answer?
Yeah. I appreciate it. Thank you.
Sure.
Thank you. I'm just really grappling with this because I see the problem. Are you familiar with the concept of mens rea?
I'm sorry? Mens
rea, the idea that someone knows what they're doing, that they are knowledgeable about what they're doing. People who are about to overdose do not know they are about to overdose. So I don't even know if this would stand up to judicial scrutiny. It's impossible.
Sure. And in this, it is public use that results in the overdose. It's not that they know they're about to overdose. And so I think, you can look at other charges that fall under drug court, like petty theft, right? Someone could argue that in the time of that activity, they were intoxicated and didn't know what they were doing.
So the use, though, is not like there's usually, I know how it usually goes. They go into the bathroom, they use in the confines of a bathroom where they're not exposed to the public, where there's an assumption of privacy, and then they hopefully leave the bathroom, but a lot of times they can't get out because they've accidentally overdosed. They don't know that's going to happen. I just don't think you could charge somebody the way this bill is written, and I question whether or not this is going to be actually helpful at all, or maybe more people will just end up dying, frankly.
Seeing no further questions for the delegate, that will conclude the testimony of those in favor. So we'll go now to those opposed. Yeah, it concludes the testimony of those.
Sorry, I apologize.
I'm sorry. Yes,
next time, I don't know, I'll wear a megaphone or something. Thank you.
No problem. No, that was her first bill in Judiciary. Ann Seacott, Stacey Jefferson, Holland Brownlee, Owen O'Keefe, and then virtually we're supposed to have Christina Trenton Nay, Michael Beach, Shelley McIntyre. Just Christina is on. Who would, Ms. Seacott, we'll let you start.
Thank you very much, Mr. Chairman, members of the committee. I'm Ann Seacott on this beautiful day. I'm representing several organizations, the National Council on Alcoholism and Drug Dependence, the Maryland chapter, the Maryland Association for the Treatment of Opioid Dependence, the Maryland Addiction Directors Council, and the Maryland, D.C. chapter of the Society of Addiction Medicine. We respectfully oppose this legislation, and we appreciate that the intent of the sponsor is to help get people into treatment. But we believe this bill will keep people in the shadows where they will still use drugs behind closed doors and they will die. This is the opposite of the policy the General Assembly has been supporting and working on for the last 10 years with the Good Samaritan Law. We know there are interventions that work that do not rely on criminalizing the public health problem. For example, in Baltimore City and in Baltimore County, there are certified peer recovery specialists working in the public libraries, engaging with people who are experiencing homelessness, who have drug problems, or may have mental health challenges. They are helping them find resources that might be available to them. There are other programs in jurisdictions around the state that are finding ways to provide interventions that do not involve arresting people. There are outreach teams that follow up with people who have survived overdoses. There are safe stations right here in Anne Arundel County where people can walk in and without fear get help. These are the kinds of interventions and programs that meet people where they are, make them feel safe, and when they're ready, are able to get them into treatment and start their journey of recovery. We ask that we focus on these kinds of efforts that do not revert to criminalizing this public health crisis, and we ask for an unfavorable report.
Good afternoon, Mr. Chair and members of the committee. My name is Stacy Jefferson, and I am the Director of Policy and Stakeholder Engagement for Behavioral Health System Baltimore, but I also come before you today as a family member who lost 2 members of my family to overdose. So this issue is very important to me, and they died in the shadows at home alone. House Bill 667 is the wrong approach to getting individuals connected to treatment. This legislation will cause harm, as we have seen with the war on drugs, particularly in Black and brown communities. Instead, we must continue to resource and promote efforts that have been proven effective in connecting individuals to treatment and supportive services. And I just want to quickly highlight 2 in Baltimore City. We have street outreach. The group is called Be More Power. They're a harm reduction network of persons with lived experience related to drug use. They deliver harm reduction tools and educate the community. In fiscal year 2022, they distributed 15,000 naloxone kits and reported over 2,200 overdose reversals. In addition to that, through legislation supported by the General Assembly, Baltimore City has a stabilization center that's located in West Baltimore. This is a crisis center that they provide services for persons who are intoxicated from drugs and alcohol. People can walk into the center, or they can be referred by hospitals, by other programs, as well as peers and others. And so, in the data that we have from July 2021 to December 2022, there have been 7,000 admissions, and that is over 7,000 people connected. And they also receive services afterwards. They are transported if they are looking to go to other levels of service. And so with that, we ask that you invest in supports that we know work, and we ask for an unfavorable report on House Bill 667.
Good afternoon, Honorable Chair, Vice Chair, and members of this committee. I am a felony trial attorney with the Office of the Public Defender, and I've been practicing law on the Eastern Shore for over 14 years. I'm asking for an unfavorable report on this bill. According to the CDC, almost 1 million people have died from drug overdoses in the United States since 1999. In 2014, this legislature passed the Good Samaritan Law, which is designed to protect persons experiencing a drug or alcohol overdose and those who seek or provide assistance for an overdose from arrest or criminal prosecution. Currently, 47 states and D.C. have enacted both Good Samaritan laws for drug overdoses and naloxone access laws. The remaining 3 states, Kansas, Texas, and Wyoming, do have naloxone access laws as well. According to a 2021 report from the U.S. Government Accountability Office, there are lower rates of opioid-related overdose deaths among states that have enacted these Good Samaritan laws. HB 667 seeks to circumvent our Good Samaritan law by reimposing criminal liability on drug-addicted Marylanders. Our citizens who are not intending to overdose when they use and who are just trying to get by one day at a time and who are usually just trying to deal with their trauma, their mental health, and other problems. We keep telling the state's attorneys, the police, and the courts, jail is not the answer. At best, this bill is passed and more people will go to jail. Maybe they'll get help that way, maybe they won't. At its worst, this bill is passed and people will die in their homes or hotel rooms rather than call for help. And then all the good created by our Good Samaritan law is lost. I beg you not to pass this bill, and I'm asking this especially for the many, many clients I have lost to the opioid epidemic. Thank you.
Good afternoon, Chairman and members of the committee. My name is Owen O'Keefe, and I'm here today representing Baltimore Harm Reduction Coalition. I'm also here today as someone who has been born and raised in Maryland and lived here my entire life, from Frederick to Prince George's County and now in Baltimore City. I'm here in strong opposition of House Bill 667 to criminalize people for overdosing in public. This bill specifically targets the community my organization works tirelessly to serve. Poor people facing housing insecurity who do not have a private place to live, let alone to use drugs. We've come a long way in understanding that criminalizing people who use drugs does not work. It's really disappointing, honestly, to be here to see that we're still trying to come up with new ways to do that when we have so many laws already that accomplish this. While drug court may work for some people, it doesn't work for many, and especially for people who are unhoused and poor. I'll tell a story of a friend of mine who I unfortunately ran into on the street late in the summer. He had recently been released from incarceration and was referred to a mandatory substance use treatment program. When I ran into him, he begged me for money so that he would be able to get a car ride home to his treatment program so that he would make his curfew, because these programs make it so that relapse or making mistakes that result in you not being able to make the demands of the program results in criminal recidivism. It was humiliating, it was sad, and it's something that we're still working through now. I'd also like to share some data that I have in my written testimony around opioid-related fatalities in Massachusetts. They discovered that individuals who had a history of involuntary treatment were more than twice as likely to die of an opioid overdose than those with a history of voluntary treatment and no history of involuntary treatment. I know these programs work for some, but they do not work for all. Mandating treatment is not a carrot. Housing, supportive services, and access to compassionate care for people at all stages of their drug use is what we need, not more penalties. I urge the committee give House Bill 667 an unfavorable report.
Christina Trenton, please. For 2 minutes. Need to unmute yourself. There we go.
Thank you. Mr. Chair, members of the committee, it's not illegal for a type 1 diabetic to go into ketoacidosis in public as a result of not taking their insulin as prescribed. It's not illegal for someone to have a stroke in public because of blocked carotid arteries due to heart disease and poor diet throughout their life. Why would we make it illegal for someone with a chronic disease, no different than diabetes or heart disease, to overdose because of an untreated substance use disorder? People with chronic diseases do not present a public safety risk. This includes diabetics, individuals who have strokes, and incapacitated overdose victims. While this bill may be well-meaning in trying to protect the public from scary encounters like public overdoses, it should not be a crime to suffer an adverse event because of a health condition. People with a substance use disorder have zero control over how their body is going to respond to a drug. Forced, coerced treatment is not always effective. Persons with substance use disorders are most often in the pre-contemplative stage of change. They're unaware they have a problem, or they have little or no consideration of changing their current pattern of behavior. Forcing these folks into drug court will not necessarily move them into the stage of change in which they are committed to take action on their substance use disorder. Arresting people in order to get them into treatment has been something we've been doing for over 40 years, and the challenges of substance use remain. It's not the solution. Addiction is a chronic disease of the brain that can be successfully treated and from which one can recover. All of our public health and all of our public safety suffer when we use the police, prosecution, punishment, and prisons to solve our public health problems. Thank you.
Mr. Beach, for 2 minutes, please.
Thank you, Mr. Chair, members of the committee. Sorry I got disconnected, and I'm likely echoing a lot of what everybody else has said, but also urging an unfavorable report on the bill for criminalizing a public health situation. And as others have said, encouraging people who engage in risky behavior to do it behind closed doors, which will make the epidemic worse than it already is. The other thing that's, we don't put enough resources into dealing with our clients who have substance abuse disorders and substance use disorders. The cost of this bill is, as our office, I submitted some information for the fiscal note, would be staggering. There are, I think through the year up to August of 2022, there were thousands. I think there were 9,000 EMS naloxone administrations and 8,800 non-fatal opioid-related emergency department visits. You're going to start criminalizing all of those people. You're going to be using the cost of incarcerating them, the cost of prosecuting them, the cost of arresting them. And if you try these cases in court, the cost of bringing a toxicologist to prove that somebody meets the definition of overdose in the bill, that's a staggering amount of money that we're going to be spending criminalizing a public health problem. Think of what we could do with those resources to help the people who are struggling with these serious health issues. So, and people will get, the word about this will get out there in a bad way and encourage people to go behind closed doors. People know about the Good Samaritan law, and I think that's a good thing. People know they can call when somebody's overdosing and not be prosecuted. And I think people will hear about this, and a lot of risky behavior will move behind closed doors, which will make things worse. Thank you.
Any questions for the panel? Delegate Conaway.
Mr. Chairman, thank the panel for coming in to testify. To the lady that said I think you said 2,200 overdoses in 2022?
No, so reversals. So that was the numbers for the street outreach team, yes.
For the
So it was 2,200, yes.
That got the Narcan spray?
Yeah, they use the spray, or sometimes they also use the intravenous Narcan as well.
And then after they did that, did the person who received that treatment, they got a citation?
No, these are outreach workers, so they're peers. So no, they are talking to people, they're building relationships, and then some cases people are getting, going to treatment, and so they're also helping them if they want to move on to treatment. But no, these are peers that are helping and doing the reversals.
So when the peers do the reversals, healthcare worker is not called, ambulance is not called?
And so, yes, in some cases they will be called.
And to your knowledge, when they call an ambulance, does the person who gets the reversal, do they get a citation?
No, they should not be getting a citation.
Okay. But in this bill is talking about if you violate this, the person is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 60 days and a fine not exceeding $500 or both. So we're not giving out any citations at this point, right?
No, we should not be.
But if this bill were to pass, the court may refer a person to the to drug court versus they shall. You understand what I'm saying?
Courts can do that now.
Yes, but it's not being done. There's no citations being given now. That's what I'm trying to get to. Is that correct? Generally, right now, like the gentleman was saying, the word on the street is we're trying to save people's lives.
Right.
But now, in this change in the bill, we're going to be giving people the fines and the citations because they're going to have to go to court to explain what actually happened, and they might get 60 days and a fine or a fine not exceeding $500 or both.
Right, which is what we're hoping won't happen.
Right, exactly. That's the point I was trying to get to. Thank
Yes.
you very much.
Seeing no one else with a question, that concludes the testimony for House Bill 667. Thank you all very much. Delegate Grammer, 2 bills. Which one do you want first? All right, 714, which is out of order on the calendar, which is just going to make everything fall apart. That's all right. I know.
The only reason I ask is I have a small panel and we could let them go.
All right. That's fine. Mr. Seltzer, Ms. Pirelli, Ms. Bailey, Mr. Cox is here, is testifying favorable with amendments. Do you care if he's up there at the same time?
Fine with me.
Come on up, Mr. Cox. Let's do that. And those are all the people that testify. We'll add a chair, and that'll be fine. Delegate Grammer.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 714. House Bill 714 allows for the lawful intercept of wire, oral, and electronic communications in cases of imminent danger and as admissible evidence. My interest in this case stems from a case in my district suffered by a pair of young women. These women lived next to a neighbor who had a problem with their marriage and made clear that he disagreed with it. This person would bring grief to the lives of these women literally at every moment possible. He was at the fence when these ladies attempted to eat lunch on their back patio. Every single time, literally, that the couple stepped outside to go to their car for any reason, he would be there, assaulting them verbally, using the worst pejorative comments you can think of, stealing their parking spaces when they left for work. This person flung racial pejoratives at the mailman for the crime of delivering the mail. For these 2 women, living next to this man was hell. His actions make living at their home impossible. Frankly, these young ladies just wanted to leave Essex. I directed them to get a peace order, and the actions of this person fell within the bounds of a peace order. The problem is there's a burden of facts to get a peace order, and the burden is on the plaintiff. So how do you prove that? You don't. And that is what happened to these young women. The peace order was denied. It took months until a police officer could be on site and witness an actual infraction for a peace order to be granted. And during this time, these women went through hell. House Bill 714 attempts to fix this problem, and it does so by making exceptions in the interception laws that allow for the lawful intercept of wire, oral, or electronic communications in cases of imminent danger and as admissible evidence. Maryland is one of seven all-party states with no exceptions for imminent danger or admissibility of evidence. There are facts that exist despite an inability to prove them. All but 7 states have put in place a provision that allows exceptions similar to these so that the truth can be captured in cases of imminent danger and if its admissibility is in the interest of justice. We should do the same for the people of Maryland. Thanks for the opportunity to present House Bill 714. Be happy to take questions, and I'd ask for a favorable.
Good afternoon. My name is Yosefi Seltzer. I'm an attorney at the JAG office at Fort Meade, and I'm speaking today in support of House Bill 714. I'm here on behalf of our office's clients who are victims of domestic violence. The current all-party consent law creates a chilling effect that intimidates victims of domestic violence from coming forward. Victim intimidation is common in these cases, with the abusers telling the victim, "No one will believe you." Maryland has been leaving behind domestic violence survivors. In the dismissal granted third chart before you, more than 54% of the statewide protective order petitions were dismissed or denied last year. That's almost 13,000 petitioners who were denied protection. They could fill the Baltimore arena. In Prince George's, Baltimore City, and County, more than 58% of the petitions were dismissed or denied. This bill will bolster the testimony of victims, which should result in a greater number of granted protective orders. As the first chart you have shows, the federal wiretapping statute and military rules of evidence, along with the majority of states, admit audio recordings under a one-party consent theory or using an exception to all-party consent. Similar to this bill, California, Nevada, and Washington State allow recordings for protective orders and emergencies. Florida authorizes recordings to prove a violation of a protective order. All 4 states are all-party consent states, but they wisely authorize exceptions to help domestic violence survivors. Maryland should join them. Some time ago, evidence such as nanny and security camera footage, fingerprints, and DNA evidence were debated. If authenticated audio recordings are available, shouldn't a judge or jury be allowed to hear them when evaluating witness credibility and deciding guilt or innocence? I think everyone can appreciate the critical role recordings of violent confrontations can play in achieving justice. Let's also not forget that domestic violence survivors and their children have civil rights and civil liberties. They deserve to live free from violence and fear. It's now time for Maryland to lift the exclusionary rule on audio recordings made and offered by domestic violence victims. Survivors should no longer be left behind. Thank you for your attention, and I welcome your questions.
Thank you. Please.
Good afternoon, Mr. Chairman and members of the committee. My name is Anita Bailey. I'm an attorney who has practiced in the areas of family law and domestic violence for more than 26 years. I am currently the Chief of Legal Assistance at the JAG office at Fort Meade, and prior to that, I was the Chief of the Anne Arundel County Office of Maryland Legal Aid, where I represented hundreds of clients in connection with domestic violence petitions. I believe this bill will greatly benefit victims of domestic violence. I've counseled a lot of victims who often had recordings of their abusers threatening them, or even captured some of the acts on audio or video recordings. My clients were often afraid to go forward with obtaining protective orders or filing for violations of protective orders because the recordings would be inadmissible and they didn't have any other proof to back up their allegations. Abusers rarely commit acts of violence against victims with witnesses present. And it creates a great chilling effect, as Mr. Seltzer said, on victims to move forward with their cases. My written testimony provides an example of a client who suffered years of abuse at the hands of her husband. She actually obtained a protective order against him, but it gave him visitation with their son, and the husband would use those opportunities to threaten and coerce their son against her. This ultimately led to her giving up custody of her son because she felt that if she proceeded with the case, first of all, she didn't have a lot of evidence on her side, but she also feared that he might kill her if she actually succeeded. Therefore, I believe that the current amendment that is proposed would be very beneficial to clients such as mine, and I'm asking you for a fully favorable report.
Good afternoon, Mr. Chairman, members of the committee. My name is Amber Pirelli. I am a legal assistance attorney also at Fort Meade. I am here offering this testimony in support of House Bill 714. The exception offered in this bill would greatly impact domestic violence victims and survivors. As Ms. Bailey mentioned, we are often confronted with the question from our clients of, can they record the abuse when it happens? Will they be able to present that information in court? And we are in the unfortunate position of telling them no, they cannot present that to the judge. The judge will not hear that. And again, these victims are left in a situation where oftentimes these acts occur in their home, and it is just the abuser and the victim present. There is not an independent eyewitness or anyone to corroborate what was happening. It's a very difficult position for the victim to be in this type of situation where it's a he said, she said situation. This limited exception would greatly assist these victims, allowing them to bring in an audio recording of the actual incident as it was occurring. The way the law currently states in the case of Wood versus State, it's a different situation regarding the facts of the crime. However, in this case, the victim asked the defendant for money so that he would not testify against him at trial. At trial, the person still testified and said they never offered that money. That conversation never occurred. When they attempted to introduce this recording of the bride to not testify, the court would not allow that recording to come in either as substantive evidence or as impeachment evidence. The judge and jury never heard that information. Oftentimes, abusers will often falsely accuse their victims of a crime. The audio recordings would greatly help in this situation as well. Thank you.
Thank you, Chair Klippinger, members of the Judiciary Committee.
a coincidental connection here. 37 years ago, I was an Air Force JAG officer. So it looks like we've got it all covered here. But now I'm the Deputy State's Attorney for Baltimore County and speaking on behalf of the Maryland State's Attorneys Association, supporting House Bill 714 with a proposed amendment, which I'll address very quickly. But it makes absolutely no sense that we're saying that if somebody imminently believes that they're just about to be robbed or just about to be raped or just about to be even killed, that they are a felon if they turn on the recording device on their cell phone right before that crime happens to them. And that anything that's recorded cannot be used in a courtroom. That makes absolutely no sense. And so it makes every bit of sense that we have this bill to address that. There are, I think, 11 other exceptions to the wiretap statute prohibiting the recording of an oral communication. This ought to be one of them also. It makes absolutely no sense. The amendment that I propose is to remove the section addressing the admissibility of the evidence with the restrictions that it imposes. For all the other exceptions that we have to the wiretap statute or the prohibition on recording, there is no special rules by which that could be used. The statute says if you record something in violation of this title, then it can't be used in a courtroom. That ought to be true for this also. If somebody records their own rape, there ought not to be additional restrictions on its admissibility other than the already existing rules of evidence. It certainly has to be material to the case that's before you. It has to be relevant. Its probative value cannot be outweighed by unduly prejudicial evidence. I don't see a reason to have restrictions on the admissibility of that evidence for something that makes absolutely every bit of sense ought to be allowed to be recorded.
Questions? Delegate Arakan.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this. I'm typically a big fan of our two-party recording system. I think it's one of the great things about our state, but I totally see now why there could be some situations where we might consider a carve-out. So I'm certainly more amenable. I was thinking, though, about the first two women. I guess since they were at their properties, that's why they couldn't, it wasn't like considered a public space because they were on private property. Both of them were on private property.
Yeah, they were. I mean, literally, it's at their home, and you know, it presents a case of the, you know, a lot of times a thing is true, but unless you can admit that evidence to court, it really doesn't matter, and you could suffer forever, and that's part of the remedy. You know, I kind of share your concern about privacy, but I can hold mutually exclusive admitting that as evidence, that exception, which several other states have done. When you're presented with a crime that's going to happen to you, you know, this is today's shield. We're going to do this. We're going to whip this out. You know, and none of us are going to think of it. Nobody's going to say, well, that's a felony. I can't do that.
Right.
So I think it's something you know, everybody could agree on, but it's also, I think it's very necessary. And frankly, I think a lot of people are denied justice because we don't have this exception.
Yeah, I'm really thankful for you for bringing this forward, but I'm sorry your constituents had to be abused in order for us to touch on it. Did you want to add something?
I did. Thank you, Delegate. So just one clarification. Maryland's an all-party consent. I hear, unfortunately, many times people say two-party consent.
Right.
No. If there are 5 people in the room, all 5 people present in that conversation have to give consent for that recording to be admissible.
Right.
The other clarification I wanted to offer was that the Supreme Court's ruled on this issue in U.S. v. White and Lopez v. United States that there is no Fourth Amendment issue whatsoever. As long as the individual who's making the recording is present with the consent of the other parties that have invited them in, there's no no coercion involved, correct? So there's absolutely no constitutional problem with what we're doing, what we're proposing, and what 35 states plus DC are already doing, and other states have carved out exceptions for imminent danger. It's simply a statutory problem in Maryland. That is all it is, that when this law went into effect, it was inartfully drafted. I mean, the term intercept, think about that. Is that Lamar Jackson throwing a pass to Mark Andrews?
Yeah.
If you had, you know, a Pittsburgh Steeler intercepting the conversation, okay, they are not a party to that pass, right?
Yeah.
So the term intercept is not appropriate either.
Yeah.
But that's what we're stuck with in the statute, so we're hoping that this committee we'll take action.
Yeah, well, thanks for bringing this bill forward, you guys.
However unlikely it is that a Pittsburgh Steeler would intercept anything.
Are there further questions for this panel? Oh, sorry, Delegate Cardin.
Please, another Steeler joke, please.
No Steeler jokes. Maybe Buccaneers joke.
Oh, here we go.
Okay. So I'd be curious, although we don't need to go into now, what was the original reason for all-party consent that Maryland had, and I understand we're trying to, I guess, protect privacy of people. But it would seem to me that if you use this as an excuse, you use the imminent threat as an excuse to be able to get it out, and then it becomes part of a scheme to, I don't know, to create a case for a divorce case, or it's already on the record because you've gotten it for a protective order hearing that may have been denied, or maybe it was allowed, but then, you have this on the record. Now you can use this, even though it was used as an excuse. I'm trying to figure out, kind of play devil's advocate. I guess this is for Mr. Cox, really, to say, what happens when people, when lawyers are suggesting to people, oh yeah, we can get this information in now because we have this exception that we're going to use, and we're going to figure out a way to get it in, and then we're going to win this custody or other things.
Well, I hope the easiest way to address it is the way that the bill is drafted. It says when the person reasonably believes that that person is in imminent danger of becoming the victim of. So there would have to be a reasonable belief. You can't use a ruse. And if somebody were to find that it was in fact a ruse to try to record something, then that wouldn't fit within this bill.
Available then, because you had the hearing, or let's say that the temporary was granted based on this, and then it was denied for the permanent, and then do you possibly already have it on record, and therefore it can be used?
My mindset is on the criminal prosecution. I don't deal with the protective orders in great detail. I guess. Theoretically,
you go to the judge saying, I need a protective order against this guy. Here's a recording of him saying, I'm gonna bash your brains in. But it really wasn't him. He was actually, what he said was, did you see that movie where in The Shining where the guy says, I'm going to bash your brains in? And then she says, oh, wait, this is a great thing. You've got him saying, I'm going to bash your brains in, and then we can get the $1 million he has in the condo in Florida. So let's go and get a protective order. The judge hears it, says, yeah, we're going to grant the temporary, and then they come back and there's a little bit more work done, and they realize that they
Very hypothetical, Delegate. Very hypothetical.
Delegate, I would like to respond.
You know what committee you're in front of? Really? That's your answer to that? It's very hypothetical?
It's exceptionally hypothetical.
Okay, fine.
So Delegate, currently, that individual who's orchestrating that scenario you described, there's no legal prohibition on them coming into court and testifying to everything you just described. It's just that currently they can't admit an audio recording of that conversation.
Right, but if the judge
So if they're going to commit perjury, they can do it now, and that's allowed. Well, it's illegal, but they could go about and testify improperly, right? So that's one of the things the Supreme Court rationalizes. If a witness can testify to a conversation that they had with the other individual, allowing an audio recording to be admitted is no different. And in fact, it's more reliable evidence of that conversation. And obviously, there's cross-examination in a contested hearing or at a trial. You're concerned about it being brought into a domestic relations case. The judge is always going to be the gatekeeper on evidence. Relevant, it has to serve the interests of justice. There's criteria the judge will be the gatekeeper on admissibility of that.
All right, thank you. Thank you very much.
Thank you, Mr. Chair. You had me at domestic violence. You lost me on page 3 at C1, where it says that we get to get it. What do we need it for?
I'm sorry, where?
Well, it says any wire under C1 on page 3. If I'm reading it correctly, it says any wire, et cetera, may be received as evidence in.
I think that was derived from laws in other states, and I'm fine with striking that if that's the will of the committee.
Okay, are you also fine with striking the word officer? Because it doesn't quite make sense anyway. And striking or any or other authority of the state or a political subdivision of the state. It just seems like we've gotten a little too broad with, you know what I mean? Okay.
Yeah, I think that's workable, Delegate.
Okay, all right, thanks.
Yeah, I mean, the goal of the legislation initially, the intent was to allow evidence to be admitted at hearings for protective orders and then grand juries for criminal matters that involve rape, murder, assault, et cetera, as well as trials of those types of crimes.
Yes. Would you be willing to amend page 2, line 15, from felony to misdemeanor?
You know, Delegate, I think this panel probably has some strong feelings about that. You know, I'm always open to a discussion.
It was worth a question.
Yeah, you know, look, I don't look at this. You know, I'm personally willing to discuss that. So, if it's the will of the committee to look at this bill, send it to subcommittee, we could definitely put some work into this one.
I would just comment, if I may. There have been no prosecutions, to note, in Maryland of the wiretapping law. So despite it being a felony on the books, it's not being prosecuted. I think there was one rare case recently. But it's really the exclusionary rule that's the problem for public purposes and domestic violence victims. So that's why we're here, is to ensure that it's admissible in court.
Any further questions? Seeing none, thank you all very much. That concludes 7:14. We're now going to 7:15, and this one will be Delegate Grammer by himself to start. And then we have 3 people testifying in opposition. So let's go ahead with that one.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 715. House Bill 715 requires that a person convicted of a violent crime serve 80% of their aggregate sentence for violent crimes or 25% of their aggregate sentence overall, whichever is greater, before parole eligibility. It also requires those serving life sentences to serve 40 years before parole eligibility. We all recognize the seriousness of our problems with violent crime. It is a growing issue for Baltimore County. Instead of focusing on a specific charge, what this bill does is it makes sentences for all violent crimes adhere when a person is actually convicted. This piece of legislation was requested by the Randallstown NAACP. I appreciate Ryan Coleman specifically for his help and support with this legislation. I recognize with him that violent offenders committing crimes have a disproportionate impact on racial and ethnic communities. Ryan Coleman of the NAACP has included testimony, which I hope you will read. I'm going to steal directly from his analysis, which looks at the murders in Baltimore County in 2021 and 2022. Baltimore County experienced 77 murders in these 2 years. Out of the 70 suspects charged with murder, 90% were previously convicted of a felony, and 25% were on probation at the time of the murder, and 17 would have been in jail had they been required to serve 85% of their sentence. Had this law been in place, 22 Baltimore residents would be alive today. When you assess the cases in aggregate, you will clearly see that those who commit violent crimes has a pattern history that is recognizable. This bill attempts to reduce crime by making the penalties stick on those convictions. In 1995, Virginia passed an 85% rule requiring all convicted felons to serve 85% of their sentence, which has served to help reduce overall rates of violent crime in the state. 28 states have an 85% requirement for violent offenders. 4 states have a 100% requirement, and 6 states have a 75% requirement. We can unilaterally reduce violent crime by ensuring those who are convicted of violent crime actually serve a significant portion of their sentence. I concur with President Coleman's words. This is not about Democrats or Republicans. This is about saving lives and ensuring public safety. Thanks for the opportunity to present House Bill 715. I'd be happy to take questions, and I'd ask for a favorable.
Are there any questions for Delegate Grammer? Seeing none, thank you very much.
Thank you.
We'll hear from those in opposition, including Mr. Pack, Ms. Kirsch, and online, Ms. Desiderio. We'll take the two people at the table first, and then we'll go from there. We'll begin with Ms. Kirsch, please.
Thank you. I'm Ann Bocchini-Kirsch. I am Director of Advocacy for Prepare, and we do parole advocacy and reentry support. This bill does a terrifying thing. It interacts with CSA 7501 and CSA 11504 in such a way that it abolishes parole for anybody with a violent crime, which, by the way, can be something as simple as stealing a purse off the back of a chair. It doesn't mention that in the bill directly. It just makes a mathematical change that and I go through, because it's a rather complicated math, I go through it in my written testimony, and I can provide additional information about the calculation of diminution credits or mandatory release if necessary. My email's at the top, and I've written something for the second edition of our book that is going to be published upcoming. So my concern about doing something like this in the background through a mathematical change that makes someone's mandatory release prior to any possible parole hearing is that we don't talk about the issues that are created by abolishing parole. We're not looking at the importance of the parole system in guiding people's reentry. We're not looking at the importance of offering work diminution credits, which, by the way, are also eliminated by the very high percentage of 85% set by this bill. We're not looking at any of those things specifically. We're not discussing any of those things specifically. We're just throwing a number out into a very complicated system of commitment and parole eligibility calculation without thinking of any of the collateral consequences or any of the impacts that it has when put together with other statutes. So I think that before anything like this should be considered, we need to look at all of those things, and I urge an unfavorable report at this
time. All right, good afternoon. My name is Gordon Pack. I'm a resident of District 41. I'm also a returning citizen, and I'm a parole advocate for Prepare, the same organization that my colleague just spoke about. I oppose this particular bill for two reasons. One, I think it's too soon for us to revisit this issue. In 2021, this legislator just took the governor out the parole process and enhanced the parole eligibility from 15 years to 20 years. It's only been 2 years. And this has been on the books for almost 50 years, that 15. And it took considerable effort for it to get to the point where that decision could be made. Secondly, I believe that the whole issue, raising the parole eligibility from 20 years to 40 years is double for one. Also, removing the possibility of having early parole consideration because you don't allow for diminution credit. That just seemed kind of sacrilege to me because in 1971, the legislature determined that it would be a good incentive for those who committed violent offenses, the so-called worst in the system, to have some type of incentive to conform to certain behaviors. And because of that, the prison population changed. The environment became more safer because they stopped committing violent acts because they were trying to get out of prison as soon as they possibly could. They started participating in education vocational programs. Now the idea, if you take that away, it's a more dangerous and unsafe environment for not only prisoners but staff as well. And if we look at the numbers, if I can just mention them real quick before my time is up, it costs $46,000 a year to average or house the average prisoner in prison. Most of their life is kind of age out. 50 and 60, they have health issues, so the price even increases. So having someone in prison for an extra 20 years before he's even considered for parole is a great bill. for Maryland. Thank you.
Ms. Desiderio, please, for 2 minutes.
Good afternoon again, all. I'm Elise Desiderio with the Office of the Public Defender, urging an unfavorable report on this bill that would mandate that in most circumstances, a person convicted of any crime of violence is not parole eligible until they've served 85% of the sentence. And if they're serving a life sentence for a crime of violence, they have to serve 40 years day for day with no diminution credits. This bill would be a harmful departure from current law. Today, a person serving a sentence for violent crime is generally eligible for parole after serving half their sentence. And people serving parole eligible life sentences become eligible, depending on when they were convicted, between 15 and 20 years with diminution credits applied. So these are huge differences. Crucially, members of the committee, parole eligibility and parole release are not the same. The Parole Commission already makes measured, individualized choices about a person's suitability. Further restriction is harmful and unnecessary. This bill proposes an unreasonable solution to a problem that does not exist. This bill is especially problematic considering Correctional Services 7501B that mandates that somebody convicted of a violent crime isn't eligible for mandatory release until that person's eligible for parole. So this bill means that a person serving a sentence for any crime of violence has no option for release before they've served 85% of their sentences. This imposes essentially mandatory minimum sentences for all crimes of violence. It would make prison time less fruitful for people convicted of crimes of violence because delayed mandatory release dates affect a person's eligibility for programming. And the last thing that we want to do as a state is to deny rehabilitative programming to people convicted of crimes of violence, arguably people most in need of that programming. Parole eligibility also affects ability to pursue substance abuse. Through 8505 and 8507, the outcomes don't serve the public interest in rehabilitation and community safety. We urge an unfavorable report. I'm happy to take questions.
Questions? Delegate Boucher.
Thank you, Chairman. This is for the Public Defender's Office. If we come to a point where the prisons are starting to get overcrowded, is there a possibility that judges could run the 85% calculation and actually start giving out shorter prison terms to offset this?
I mean, I suppose technically, yes. However, that's an added sentencing consideration that A, we don't know which judges, if any, would actually do, and B, the diminution credits problem still persists, that the problem isn't solved by judicial discretion, I will say.
Thank you.
Further questions? Seeing none, we thank you very much, and that concludes the testimony on 715. We're now going to go to 660, and Delegate Alston, please. Joined by Yannette Emanuel and Mary Denise Davis, if they're here. Okay. Delegate Alston for 3 minutes, please.
Good afternoon. Thank you, Mr. Chair, Mr. Vice Chair. It's a privilege to be able to sit here in the Judiciary Committee to present House Bill 660 to you all today. This bill is about who we are as a people and what we believe. I would hope that we are not distracted by the types of crimes that are included for expungement. We should be more focused on the fact that as a people, we tell folks that there's redemption, there's rehabilitation, there's hope, there's the opportunity for you to participate as a full citizen in society. However, for many people, when they're released from prison or released from their terms of confinement, whether it's incarceration, parole, or probation, they continue to live with the stigma of having a criminal record. This haunts them. It makes it nearly impossible for them to participate fully in society by doing things as basic as finding a place to live, finding employment, being able to vote. And so several years ago, we passed sweeping changes that allow for people to expunge their records so that they can become full citizens again in society. And the world did not fall apart. And this committee worked very hard on that bill. And as you all noted, there are times when it's time to go back and revisit, and this is one of those times. This bill will allow for the expungement of DUIs. Many of us probably know someone with a DUI, and they're normally pretty good people. They're not people that go around breaking the law regularly. It's something that happens. I'm not making an excuse for their conduct, but it is something that happens. It will also allow for certain felonies that are violent in nature. But what I want you to focus on is the length of time that a person would have to wait before they're eligible to even apply for an expungement. It's 15 years after the completion of their term of their sentence. So if a person was sentenced to a 10-year period for carjacking, they would have to serve that 10 years. If they then were sentenced to parole or probation for 3 to 5 years, they would have to serve that term as well. And then 15 years later, they would be eligible to apply for the expungement. And the state's attorney would have the opportunity to have input, to have a hearing, and to oppose it. So I asked for a favorable report on House Bill 660 because as a people, we cannot allow folks to walk around with a scarlet letter C on their chest for life like they did in the book from the 1850s. Thank you.
Yes, Mary Denise Davis. I'm with the Office of the Public Defender, and we are here in favor of House Bill 660. Reading the charges, as Delegate Austin said, assault 1, robbery with deadly weapon, carjacking, DUIs. These are serious charges, and I can understand why some people would pause and say, and have hesitation. But I'm sure the reason why Delegate Austin introduced this and other legislators is because you've had constituents who've come to you and they've told you their stories of how these charges are affecting them. And that is why it's important that, we start looking beyond just, you could say, the nice convictions, the easy convictions. We have to say, should additional convictions be eligible? And those individuals are asking for the same reasons that they're asking for expungement in a less serious case. It's the same reason a person would be asking for these charges. I tell individuals who want help with expungement when they say, why can't my charge? Sometimes I just throw up my hands because I don't know why some charges are chosen and some are not. It doesn't make sense to me that there's charges, convictions that don't even carry a jury trial right that cannot be expunged. But this is this bill and these charges, and there's no doubt about it, these are serious charges. And as Delegate Austin indicated, it's important to consider because expungement needs to be, as I referred in my written testimony, it's kind of like a legal redemption. It's saying to the individual, you can move on with your life. And it's very important to consider all the factors under 10.110 that the judge has to consider before the expungement is granted. And one of them is the rehabilitation of the person, the character, and the risk to public safety. So for all those reasons, I hope that this bill finds support. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. For the record, my name is Yenna Emanuel, Public Policy Director with the ACLU of Maryland, and here in support of HB 660, which would expand the eligibility of convictions that qualify for expungement. And we also understand there's a sponsor amendment that will be brought forth, and we're in full support of that as well. As you hear time and time again in this committee, the existence of a criminal record can and does create a barrier for employment for many Marylanders. More than 80% of U.S. employers perform criminal background checks on prospective employees. Additionally, a criminal conviction also hinders individuals' access to stable housing and a range of public benefits. And furthermore, exclusion from the job market, stable housing, and countless other crucial services perpetuates the cycle of imprisonment, and without gainful employment and stable housing, individuals are forced to return to livelihoods of criminality. Lastly, I'll point to a study published by the Arizona State Law Journal that took a look at Michigan's statewide expungement data and found that people who obtained expungements virtually stayed crime-free thereafter. Rearrest and reconviction rates were incredibly low, about 7% and 4% respectively over a 5-year period, and those were almost all nonviolent misdemeanors. A person should not continually be defined nor punished for their worst day, especially after they have already paid their debt to society and served their time. And we appreciate Delegate Allison for bringing this bill forward again and urge a favorable report on HB 660. Thank you.
Questions for the panel? Delegate Bartlett, then Delegate Conway.
Thank you. Excuse me. Thank you, Delegate Austin. I just want to make sure I understand the 10-year and the 15-year. Does that go away?
It does not. The 10-year is for the time period that would toll for misdemeanors. I think it's section 2 of the code. And the 15 years for subsection paragraph 3, which are the felonies.
Okay, so that's what I was confused about. I thought you were saying in your testimony that the person, I thought you were comparing time in your testimony. Was that there, or did I just mishear?
I was explaining the way the current expungement process works. So if a person is sentenced to whatever time period they're sentenced to for their actual crime, they have to serve that length of time first and then wait the tolling time under the code, whether it's 10 years or 15 years, before they could apply and be eligible for an expungement.
So does this bill change that?
It does not.
Okay, okay. That's where I was getting confused, because I was looking for that change in this bill as you were bringing that point out. That was a little confusing to me, but I guess I should say for public disclosure that I do have a expungement bill, and I'm asking these questions because we all want to get to the same result. So that's why I was asking, just to get clarified. Thank you.
And I like your bill too.
Good afternoon. Good afternoon, Delegate. Sorry. Thank you, Mr. Chairman. Good afternoon, Delegate. I was wondering, where did you get the scarlet letter C from?
This particular one, our printing office did a yeoman's job.
You said in the 1850s or something.
Oh, that was the book by Nathaniel Hawthorne, The Scarlet Letter A, where...
Yes, that's why I was curious as to how you got to C when the book was letter A, but you didn't say letter A. So I'm letting them know that I'm very much literate in this type of literature. Okay, I got you. Thank you.
Well, since it's not adultery and they're just a criminal.
Get it?
Thank you, Chairman. How do I follow that? Yeah, so there's, I've been through the expungement process. I have probably benefited from the expungement process. I also know how difficult it can be. Sometimes being turned down and then having to go to the courts and fight it. I mean, I don't know how many years ago it was, but I had to go with a lawyer and fight to get a alcohol citation from a senior week at Ocean City from many, many years ago. But I had a fight with that with a lawyer, I think I was like 29 or something like that. And I know that not everybody's in that position to hire a lawyer to fight to get things expunged, especially something as stupid as a, alcohol citation from senior week. But so I am sympathetic to this, to certain parts. A lot of the things listed here, I'm not so much in favor of probably expunging, like the armed robbery, armed carjacking, but some of the crimes, in particular, the driving under the influence, especially looking at the fiscal note and seeing that, almost tripled the next, the guilty dispositions from fiscal year 2022 was almost triple the next one. It's about almost 1,600 guilty dispositions. And the closest next is assault in the first degree with 615. So I do like that part, and I do think that I do think that that should be expungible. So I don't know, depending on how things go, if maybe you'd consider an amendment down the road to maybe narrow this down a bit.
Yeah, yes, are you asking what I consider an amendment? And, you know, I was remiss. We are going to do a clarifying amendment because I think there was some concerns from Judiciary about the domestically related, so we're submitting a sponsor amendment for that. I'm not sure which amendment you would be referring to, but I would be more than happy to talk to you about amendments if that would get this voted out into the floor.
Thanks, I appreciate it.
Sure.
Seeing no further questions except Delegate Cardin. Delegate Cardin.
Thank you, Mr. Chair. Just wondering what you're going to do with your Scarlet C. Maybe it could be used to represent a different last name instead of the crime.
I think I'm going to bring it back for my next bill.
Okay.
Thank you. Thank you. Thank you, Mr. Chairman.
This is going horribly wrong quickly. Let's stop right there then, and we'll now hear from the person testifying in opposition. Mr. Cox, please.
Thank you, Chair. Clippinger, members of the Judiciary Committee. I'm John Cox. I'm Deputy State's Attorney for Baltimore County, and speaking on behalf of the Maryland State's Attorneys Association, opposed to House Bill 660 and asked for an unfavorable report. I was here 9 days ago and gave a little bit of history of Justice Reinvestment Act with regard to expungements, and this was a major part of the Justice Reinvestment Act and a lot of work. The legislature went through virtually every crime and gave consideration to those which they would deem appropriate for expungement at some point in the individual's life after that particular conviction. That was well beyond that which existed before, which was previously just PBJs and other non-convictions. This is honestly a bit astounding that the ones that have been picked are basically the most violent that you can think of, other than murder itself, and that is a first-degree assault. So if somebody shoots somebody, or a robbery with a dangerous and deadly weapon, pistol whipping somebody and taking their wallet, or a carjacking, dragging somebody out of a car. And that we're going to therefore expose to the opportunity for expungement, it honestly makes no sense. And to kind of confront, I guess, the inclination of Delegate Tomlinson, I brought with me a file that I did a couple of weeks ago for a sentencing for a fifth-time DUI. And this individual ran up a curb and ran into a pole, and it was his fifth DUI. His prior ones were in 1996, 2001, 2002, 2011, and then 2022. All of those would have been gone when he did his 2022 DUI. A judge would have had no idea that this guy is a 5-time DUI if we pass this bill and allow that to be expunged. I mentioned it as an example last time I was here. The DUIs are often spread over considerable periods of time. We'd ask for an unfavorable report.
Questions? Seeing none, we thank you very much, and that concludes the testimony. Wait. Sorry, Delegate Valentine had a question. Sorry.
Thank you, Mr. Chairman. Can you refresh my memory from 9 days ago? I believe it was yourself that was, and thank you for being here again. Can you refresh my memory? I believe there were some states that have no process for expungements for convictions whatsoever. Do you remember if you had testified to that or not?
Actually, the proponents testified to that because there are many that do, and I think they were citing the time frames. There were 7, if my memory serves, that have absolutely no expungement.
Nationwide, 7 states. With
I believe that's true.
Okay.
That was
I
from
could
the
not remember
proponents.
who testified to that.
Sure.
And secondly, if a conviction is expunged, say the 5-time DUI offender, and that they were all expunged, you would not be able to use that for like sentencing guideline purposes because they would no longer exist, correct?
Exactly. We could make no reference to it.
Thank you.
Further questions? Seeing none, thank you very much. That concludes the testimony now for 660. Now we're going to go to House Bill 664 that has a panel that Delegate Williams will be assembling here in a moment, and it includes Christopher Dews, Mary Denise Davis, Guy Powell, You want anybody else with you?
Maybe Jessica Emerson?
And Jessica Emerson will do that. And then we will go to the next panel and we'll begin to assemble those people who are supposed to be on virtually, but nobody's here. Okay. Well, so for that, we'll just start now with Delegate Williams and we'll go from there.
Okay. Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the House Judiciary Committee. I'm Delegate Nicole Williams of District 22, testifying in favor of House Bill 664. Colleagues, as you know, we're having a lot of conversations today about expungements, and so you will know that the criminal record for returning citizens leads to barriers to housing, employment, financial aid, public assistance, occupational licenses, et cetera, which is why we have been continuing to have this conversation all throughout this legislative session. And since I've been on this committee, we have passed legislation in the past regarding expungement reforms, regarding automatically expunging non-convictions and removing certain charges from case search, with all the extent purposes of ensuring that after individuals serve their time, that time is not the primary cause of their inability to reintegrate back into society. And this bill follows that same line of thinking, addressing all of the roadblocks to proper reentry by allowing a court to examine a conviction and see if that change should remain ineligible for expungement. So here's the process of how this would work under this bill. The individual will request a petition for expungement, just like they would currently, on a showing of good cause, though. The judge or court official would then hold a hearing and then at that point, the judge would examine the facts of the case and individual's rationale for desiring expungement, and if good cause is warranted in that case. The process and scope would take around 6 to 7 months, depending on the jurisdiction, and complete on average if the court granted the petition, similar to expungement of a non-conviction in the criminal in CP 10-105. We do have some amendments to the bill, which my office, I believe, emailed to all of you guys earlier today. If you did not, I'm happy to share those with you. And those amendments are to ensure that it's reasonable for the court to perform its intended objective. You'll note on page 5 under subsection F, we've added the following: that the court may grant the petition for expungement under this section at any time of a showing the good cause after the completion of the sentence, parole, probation, and any other form of mandatory treatment associated with the charge. An individual may petition for an expungement on the basis of good cause for a specific case involving a misdemeanor charge once every 3 years, or for a specific case involving a felony charge once every 5 years. A petition for expungement, if denied by the judge or judicial official, cannot be appealed. So those are part of the amendment. And I believe these alterations to the legislation will prevent frivolous use of this law and manage the volume of cases heard by the judiciary. So I did want to address that. I also mentioned that this bill does not make any felony conviction eligible for expungement. However, it does allow an individual to make the compelling case as to why their specific charge should qualify for good cause. And for those and other reasons, I ask for a favorable report.
Yeah, right?
I had a lot.
Cool. Christopher Dews, Job Opportunities Task Force, and representing the best interests of Alfred Justice as well. So I just wanted to kind of flesh out a little bit more what the guardrails of the amendments actually do to make sure that we're totally clear about what this bill is and what it is not. To be very specific, as the delegate has already mentioned, this bill does not make everything eligible for expungement. I want to be very clear. It is only allowing things to be eligible that a judicial official or a court official says should be eligible for expungement. So I want to be very clear that this is, the judge has to actually say, all right, this is a good cause, and I have an individual here who's going to explain as an example of what a good cause petition would look like specifically. Right now, we do have in the amendments once every 3 years for misdemeanors, once every 5 years for felonies. This means that an individual could petition once in that period, and if they are denied, then there is no appeal process. They would have to come back 3 years from now to try again. The reason for that is, as the delegate said, so that there is no frivolous abuse of this specific law. Bottom line is, this has guardrails. We kind of want this to kind of have the image of a pardon system. So if an individual has it's been 20 years, it's been 25 years, or they can't get this charge expunged because it's specifically connected to a unit or something to that effect, this would give the individual the power to at least try to get it expunged. And because you can only do it once every 3 years for a misdemeanor, once every 5 years for a felony, they're going to have to bring their best case forward. So it has to actually be a good cause for expungement, not just something that can be used frivolously. There's a bunch of other things that I could say. I will say that there was a situation that Delegate Moon is familiar with of a judge in Baltimore County who, because of a situation like this, removed an entire docket and re-uploaded a docket, removing a charge specifically because he said, all right, this is a bad, I got to be able to get this expunged even though the law doesn't currently allow it. So I'm just going to leave that there and pass it over to Ms. Mary Denise.
Hi, Mary Denise Davis with the Office of the Public Defender, and we are here in favor of this bill. I will say personally, I love this bill. Love, love, love this bill. Thank you. And I love this bill for the main reason that I cannot tell you how many times I've heard from the bench where the judge will say, my hands are tied, I wish I could, maybe talk to your legislators. And that is why it's so necessary to have this good cause exception. There is no good cause exception in the expungement statute under 10-110, only under 10-105, and that only has to deal with the time of filing. But this good cause exception under 110 will allow the judge to make this decision almost on an equity basis, and it's certainly not automatic. The state's attorney, most likely, will object, and then the judge is going to have to consider the nature of the crime. The judge is going to have to consider the character and the history of the person, the rehabilitation of the individual, and that the person's not a risk to public safety, and all of that has to be encompassed in whether or not it is in the best interest of justice. The other thing I was going to say, there's been some recent appellate decisions that, in my opinion, have kind of cut into the purpose of the expungement statute. And one of them is a petition in which the court said the individual couldn't get an expungement because they violated their probation. And it's counterintuitive that the purpose of expungement under 10-110 is to look at the individual 5, 10, 15 years later and say, what have you done? But this probation happened, I think, within a year of him getting it. And yes, he violated his probation. The judge sentenced him to, I think, 4 days. But if he has to wait another 5 years or 10 years or 15 years, why are we saying that there's an expungement statute that somebody can get expunged and the judge can look at it if there's no point in looking at it? So for me, I definitely am in favor of this bill, and I hope it finds support. Thank you.
Hello, everybody. Happy Thursday. My name is Guy Powell. Thank you for allowing me to come here today. Excuse me. I'm definitely in favor of this bill. Situation with me, I was 17 years old in 1991, and I had some guys that I went to school with, and they were very jealous and that sort of thing. And so they saw me at a restaurant. This was like 2, 3 o'clock in the morning. Back then, the clubs used to be open pretty late. So me and two of my brothers and my friend, we were in a place called Sorrento's. It's in Baltimore County. And the pizza was good. Let me tell you. The pizza was really good back then. And these guys, same guys who I had trouble with prior to that in middle school, spotted me. So one left and he came back with like 12, 13 guys. So it was like a gang. And what I did would every human being and every species on this planet have in common, and it is the will to survive. And what I did was I grabbed a knife that was behind the counter because I was afraid of my life, and I swung. And I did cut his fingers. I maimed him. And so when I went to court, they waived me as an adolescent at 17 and charged me as an adult. So never did jail time. I had to pay restitutions and fines for 5 years, supervised probation. So mind you, I was in my last year of high school, so I obtained my high school diploma, and I obtained 3 degrees. I went to Catonsville Community College, Copper State University, HBCU, and University of Maryland School of Social Work. So I've been practicing social work now for 23 years. I worked in residential treatment centers. I worked for DJS. I worked for, just a gamut of places. So now what I'm saying, I am in favor for this because of what I have not been in trouble. I've been doing what I'm supposed to be doing, and it's just unfair now. 32 years, I still have this on my record. It needs to be expunged, please. If you have any questions, ask.
All right. Little musical chairs. Good afternoon, Mr. Vice Chair, members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which provides direct representation to criminalized sex workers and survivors of trafficking. I am here to remind you that victims of crime need expungement as well. We support this bill because it would allow our clients the option to petition for expedited criminal record relief, allowing them greater opportunities that they need to better their lives. Criminal records, as you've heard me say before, are both a predictor and the result of engaging in sex work. For any individual who's trying to leave the sex trade, including those who are attempting to exit a trafficking situation, histories of criminalization are a barrier to reporting violence. They're a barrier to accessing service providers. And long criminal records mean that safe housing or finding a safe housing or a living wage job becomes essentially impossible. Arrest can lead to custody of children, denial of public benefits, and as a result, expungement has become a crucial part of these crime victims' ability to exercise control over their own lives and heal from trauma. After leaving the sex trade, HTPP clients overwhelmingly want to leave their experiences behind them and be able to provide a better life for themselves. This often involves finding a job that gives them economic stability, which is made infinitely more difficult by a stigmatizing criminal record. Given the stigma that people in the sex trades face due to the consequences of a criminal record that so commonly references things like prostitution, things like drug possession, and other crimes of survival, it is essential that any state-based remedy allow for the broadest relief possible, rather than impose additional hurdles like excessive waiting periods that prevent them from moving forward with their lives. So with this expanded access to the good cause expungement provision provided by HB 664, criminalized sex workers, including those who have survived trafficking, can petition the court to expedite the start of their new lives. So for those reasons, the HTPP supports HB 664, urges a favorable report, and thanks Delegate Williams for her support of this bill. Thank you.
Great. Let's go Delegate Cardin and then Bartlett.
Okay. Thank you, Mr. Chair. Thank you, Delegate Williams. What a great idea to try and bring some balance to this. So I have two questions. The first is for the gentleman from Sorrento, who goes to Sorrento's, love their pizza. And he actually, when Martin O'Malley won his first gubernatorial campaign, we all went there for pizza in Baltimore County because Baltimore County was a battleground state, and he bought us all pizza there.
Nice.
Okay. If you got in some trouble in the last 23 years, would you think that's grounds to maybe not allow you to have expungement? Do you think you should have like second and third chances, or just a 1 second chance?
Well, that depends on the circumstances. It depends on scenario.
Let's say you got a DWI sometime in between, after this assault case that apparently you got convicted of.
Well, if there are currently laws right now that are in place that can help rehabilitate a person versus being punitive, and I guess this is just coming from the work that I'm a social worker and I'm a mental health therapist. I'm, fairly touchy. So I'm, it's about how can we help and rehab somebody versus criminalizing and penalize them. So it depends. That's why I say this depends on the situation.
Okay, thank you. To the sponsor of the bill, Delegate Williams. I was in front of Judge Ryan a few years ago, and it was dealing with a case where his hands were tied, and he said, I would love to be able to provide X for him. It wasn't an expungement, but it was something similar. However, I can't. You got to go talk to the legislature. Maybe you can do something about this, Mr. Cardin, is what he said to me. The sense I got is that if we change the law to give them the authority, that they would be very skittish about using it, or they would be really annoyed with the additional authority that they got when they can easily just say, it's not our problem. Do you see this being an issue with judges then saying, oh, we don't really want this?
You know, I think it just depends on the judge, and this is where this goes back to kind of just the general the expungement process. Like you said, you've seen some judges, and was testified earlier today that some wish they had this ability, this kind of tool in their toolbox for certain situations. I'm not saying that this should apply everywhere across the board, and this doesn't modify kind of the current process in any way in terms of what's currently on the books in terms of the 10 years and 15 years. So that's still in place as well. And so if a judge says that, no, I'm not going to grant an expungement for good cause, that individual will still have the other expungement provisions that we currently have on our books. The other thing I did want to add, I didn't get a chance to mention when I initially gave my testimony, is that we heard about a week or so ago, we were talking, I think Delegate Valentine asked today about the number of states that currently do not allow for any expungements whatsoever. And it's a small group of states, about 7 or so. But the majority of the states that do have some type of formal expungement process, the majority of them have a lesser time period than the state of Maryland. Most of them have a lesser time period than the state of Maryland. And so I want to reiterate that really what we need to think about, and I guess this is a larger policy thought process for us as a General Assembly. Why is it that all of our other counterparts, or most of our other counterparts across this country, will allow someone to be able to go through this process in a lesser time frame than us? And the benefits that has on individuals within our society and individuals in our community. They have paid their debts to society. They have done their time. They have been subjected to all of the consequences and collateral consequences that go along with that. And so why is it that we are not willing to say, let's allow you to be able to get housing. Let's allow you to be able to get car insurance without paying these horrendous penalties or premiums. Why can't we say, yes, we will remove all of the barriers for you to get a job, remove all of these other barriers for you to move on with your life. That's what this is about. So anyway, I digress.
Thank you very much. Thank you.
Delegate Bartlett.
Thank you, Mr. Chair. Okay, quick questions. I like the bill, of course. I want to ask you about the fact, there's no judiciary opposition to go to what, I didn't see any, to go to what Delegate Cardin was getting at. And I just wanted to say, first of all, congratulations.
I know. I'm like, that's like the first in my whole career. But anyway.
But with that said, you know, Christopher Dews, you mentioned, and I'm glad that you said someone's going to come up and talk about good cause a little bit. But what I didn't see in the amendment, and what I like about the bill, unless this section at C5 is there, is that you're not defining good cause, because it is kind of a factual, situation.
Right.
And that's probably one of the reasons why Judiciary didn't oppose it, because we didn't tell them, how to think and what to do. Would you agree?
I would 100% agree, and
Okay.
that goes back to Delegate Cardin's question as well, that this is putting it in the hands of the judges to make those determinations.
Right. And so also on the, what was it, the chiefs and sheriffs, I think it was? I had to change classes. But the chiefs and sheriffs were comparing the 3-year civil statute of limitations. And I think your amendment of the 3-year, once every 3 years, is addressing their issue. Would you agree? This is to the sponsor.
Yes, I would agree with that.
All right. Thank you.
Delegate Coughlin.
Yes, to the gentleman who loves Sorrento's Pizza. I'm sorry I forgot your name. Because you talked about how good it was. We talk in a lot of, my lawyer friends in this committee talk in a lot of abstraction and code and different things like that. But I'm more interested, with all due respect to my lawyer friends, in the real world consequences of actions. So can you talk a little bit, sir, because I'm not very familiar with this area, about some of the potential consequences that still befall you because you made a poor decision when you were 17? And to my dear friend, the sponsor, could you please also, do you happen to have a list? Not a whole list. You just give me some examples of some states who have more lenient timeframes for expungement, please.
Okay.
You first, the Sorrento's Pizza first.
Yes. So that's some good pizza, though. But in regards to what was some of the pitfalls or consequences that I had for 32 years, of course, there in this country, you have a right to bear arms. Given what's going on today in the society, I can't protect my family. As a man, two things that we value the most, and that's protect and provide. So I'm ineligible to purchase anything to protect my family. Number two, when I was 18, back then the laws were, I couldn't vote. I wasn't allowed to vote at all. Since then, it's been amended. It's been some changes, some evolution that went on. So I was able to actually be able to vote for the first time in my life when the President Obama first ran. So it interfered with that. There were certain jobs that I wanted, again, to protect my family, provide for my family. Of course, everybody wants to move forward. Of course, I want to advance at a higher social economic level, but I can't do that because certain jobs, if I have a convicted felony, which again, mind you, 17 years old, I'm now 49, like that prohibit me from even making an advancement financially. So those were some of the struggles that I faced, and thank God now I was able to circumvent some of those because what I do, working with children, social worker working with children, I didn't have no offenses with children or nothing like that. So I was able to navigate through that and then having my own private practice. So, thank God for that. But my colleagues, my cohorts, my peers, I mean, it's a struggle. And so that's been very challenging.
Thank you for sharing your story. I know it wasn't easy. Delegate Williams?
Sure. To answer your question, Delegate Kaufman, some of the states that have shorter waiting periods for misdemeanor expungements include Texas, Alabama, Mississippi, Utah, to name a few. Some additional states, Colorado, Arkansas, North Dakota, Oklahoma. Maryland ranks roughly around 35th in the nation as it relates to expungement waiting periods.
What strikes
as for felonies.
What strikes me about that, Delegate, and then I'll yield the floor, Mr. Vice Chair, is, last time I checked, Texas, Utah, they weren't exactly liberal bastions of liberalism. Thank you.
All right, Delegate Tomlinson, and then Grammer, and then Conaway.
Thank you, Vice Chairman. Thank you, Delegate Williams. So is it safe to say that what is and what is not expungible, is it kind of all over the place as far as what, or really anybody?
I mean, yeah, under our current law, it's
under current laws.
Yeah, under the current law, it's a hodgepodge. I mean, but this doesn't modify that hodgepodge, but that is something we can certainly consider and talk about separately. But yeah.
And if I can just, I know I don't have a mic, but okay, all right. This is the angle. You know what? Yes. So from my understanding, I want to say maybe 2016, 2018, when the Justice Reinvestment Act was being discussed, I believe it was you guys probably know him better than I do, correct me if I'm wrong, but from my understanding it was Mr. Bobby Zirkin, who kind of just went through the law books and just kind of picked and chose which exact charges should be eligible. So correct me if I'm wrong, but from my understanding, it was kind of... Sorry, bottom line is that it was kind of chosen, not necessarily in some, great vacuum, I'm sure. Mr. Cox can explain more about that, but it was like these were specifically chosen, not by group, but kind of individually. There wasn't, at least in my understanding, like a great study or committee that was like done to say these specific ones, it was kind of like a kind of pick and chose. What that individual felt was the most.
Okay.
Does that make sense?
Yeah. Okay. All right. Thank you.
Thank you, Mr. Chair. Very briefly, the gentleman mentioned he lost his gun rights. Just so I understand, if you expunge a felony, do you get your gun rights back? I didn't think that was the way it worked.
Under the, and I'm not as familiar, it's the law that has to do with the gun permit. There needs to be language added to that if you have the conviction expunged, because I think currently the Maryland State Police is interpreting that just because you have it expunged, you're not entitled to have your, obtain the gun permit. So that language would have to be changed also.
Okay. Okay, thank you.
Thank you, Mr. Vice Chair. Thank you, delegates and members of the panel for coming in. This just keeps going deeper. So on the last comment about the gun permit, are you talking about a permit to carry or the ability to purchase a firearm? To the last lady.
I'm sorry.
Were you talking about applying for a permit to carry a firearm or permit to purchase a firearm?
I think it's a permit to have a handgun. I don't have a handgun, so I apologize. I'm not as familiar. I just know that in order to obtain a handgun, you have to first go through the application and obtain the permit. And I assume that when you get the permit, there's different types of how you can carry the gun. But yes, but in order to get the permit, you have to overcome the hurdles and the obstacles that are listed in that section of public safety article.
Right. So are you saying that if you get the conviction expunged, you still won't be able to purchase?
That is my current understanding of how the Maryland State Police is interpreting public safety article.
How would the Maryland, if you get your record expunged, how would the Maryland State Police know that you had a conviction in Maryland?
My understanding from my colleagues that help individuals with getting their gun permit is that the Maryland State Police is saying that under the federal law, the Maryland public safety article does not conform because it doesn't have the necessary language. But I could direct you to the person, Delegate Conway, that knows a lot more about this if you have questions, because I do not want to misspeak.
All right, Mr. Dews, you said that sometimes these convictions are connected to a unit. Yes. And when you have a unit, generally you have a conviction and some null process or something like that, but that normally indicates a plea bargain, right?
I wouldn't say, I mean, I wouldn't be able to, I know, right, Leland? I wouldn't be able to, like, justify entirely to say that it's only in plea bargaining situations, but I will, though that is something that is definitely a common occurrence that an individual will plea and then end up with a variety of different charges. What I would say when it comes to the unit rule specifically, which is mostly located in 10-107, is that once an individual has multiple charges in that unit, and as you all may know, none of those charges are eligible until every single one of those charges in that unit are eligible, right? So this good cause expungement, at least the way that in spirit, what we would like to see is that it would grant an ability for the judge to look at that unit situation and make a determination on an expungement. And just to the example that I mentioned with regards to Delegate Moon, there was a situation where a judge was dealing with a law enforcement officer. The law enforcement officer was not found guilty on a more heinous charge, but was found guilty on a minor misdemeanor. However, because of the unit rule, that more heinous charge could not be expunged. So what the judge had done, and this is actually what led to the idea of this bill, what the judge had done was he deleted, and this may not necessarily be the right thing to do, but he deleted the entire docket, because he couldn't expunge it because of the unit rule, deleted the entire docket and then re-uploaded the docket with just the minor misdemeanor, removing the heinous charge, which... And for the record, the judge, when he was questioned about this, said, I've been doing this for about the last 10 to 15 years, I'm not going to name names, but the individual said, because I didn't want this specific charge that he was not found guilty of to impact this person's employment, future opportunities, and things of that nature. So that's does that make...
Yeah, I understand why you're saying that, but I don't think that's a good example. Yeah. And I think someone said something about Bobby Zirkin, Senator Zirkin, picking and choosing.
From my understanding.
I don't think that you accurately portraying the character of Senator Zirkin, I think it was more to it than just he himself picking and choosing. So, as him being one of my former colleagues, I would appreciate if you would refrain from saying
And I will
things like that.
gladly retract that statement. I did not mean that in any way, shape, or form as to be an impugning on the man's theory of character. That was just the understanding that I had had.
Yeah, well, I don't think the understanding is correct, and for the record, I think he might have taken that to subcommittee or to a full committee.
Okay, I stand corrected. Sorry for the trouble, sir.
Delegate Graham, are you swinging back? No? Okay. All right. I think that's it. We'll take on the next set of folks. Thank you very much. We have Blake Donahue, John Giannetti, DeAndre Wiggins, Guy Powell, Charlotte Ahern, Harold Coleman, Nicole Hansen Mundell, and we have a couple, maybe 3 online. Ashley, no one online. Okay, so I guess you 3 are the last of the favorables. Whenever you're ready.
I'll go. Thanks, Mr. Vice Chair, members of the committee. Thank you. John Giannetti, Jr., Maryland Criminal Defense Attorneys Association. I admire what you do. Thank you for letting me speak in front of you. I wanted to say to the delegate, thank you for putting this bill in. She doesn't know I went to Berwyn Heights Elementary and Spring Hill Lake Elementary, so Prince George is in the house here. And Sorrento's, by the way, has still got good pizza. I don't know what he's talking about.
I have to go there.
It was a law school place. It was the place that was open the latest. I was a law student there and went out to off of Rolling Road. Okay, now, I think this is a very elegant bill. MCDAA doesn't come in on every bill. They sent me into this one. Here's the thing I'm concerned about. Okay, the reason it's elegant is because we can spend years deciding whether or not a person who's convicted of murder, convicted of assault, deserves to have an expungement. And that's probably what this discussions will be about. But the truth is, when you have this type of situation where a very deserving person who we can't even predict hypothetically deserves it, we're not there to try to change the law for that one person. But who's there? Well, we've empowered judges to make that determination. And the reason why this bill is elegant is because it says, hey, for good cause shown, a person can petition a judge and the judge can grant an expungement, right, for the right rich situation. And, you know, back in the day, I had a law firm with this Senator Zirkin, and when he and I practiced, we represented a client who had convicted of a felony murder when she was 17. She was trying to adopt a child. She wasn't eligible because of that. There was no way to expunge any of those crimes. We had to go and get a gubernatorial pardon, which we did get, and she was able to go through with the adoption. But that's the only recourse that anyone has now. So that's what we're doing. We're endowing our judges with the ability for good cause shown. And I know the answer to the gun question, too, if you ever ask me. Thank you.
Next.
Thank you. My name is Charlotte Ahern. I work for Maryland Legal Aid. I'm a staff attorney there. The majority of my work focuses obviously on criminal record expungement and workforce development. I just want to address some of the questions, even though I know they weren't asked to me specifically. Yesterday, the American Bar Association, their criminal justice task force, actually just released one of their publications that they've been working on for about 4 or 5 years, and they found about collateral consequences that there are over 40,000 different types of collateral consequences that can happen as a result of a single criminal conviction. You can't drive for Uber. You can't use an Airbnb. You can't get any type of, certain government benefits. It's one of the quotes that I love from, or not love, but that I liked from the report said specifically that having collateral consequences that flow from a conviction have a corrupting influence, and many of those consequences have no connection to the crime whatsoever. And I know there's been discussion about good cause and what that means specifically, but I just want to mention that this is not a new concept. Judges have discretion throughout the entire aspect of, you know, a criminal case. Even the court commissioner, when you're in front of a court commissioner, they have discretion to determine whether you should be released on your own recognizance or what type of bail amount. Obviously, there are certain you know, guidelines that they must follow, but they still have that discretion. The state has discretion as to, you know, whether they want to add additional charges. During sentencing, a judge has discretion as to what the appropriate sentence would be. So it just makes sense that it's throughout this entire process, there's these elements of good cause and court's discretion. It makes sense that it would continue post-conviction. So we urge a favorable report.
Yes, good afternoon. I'm going to reiterate on the same thing that I spoke in the last session we had. It was, you know, from 97, served my time, got released in 05. From 05 to 2009, I had to serve parole. And between then, the laws changed. They they put the expungement bill in place, and we moved forward. And now I had a good opportunity that I was just called about a job paying over 6 digits, and I cannot take the job because I can't get clearance. And it's just holding me up, and this good cause bill would really give me an opportunity to move forward and then make an example for the people that's behind me. So I urge a favorable report of this bill. Thank you.
Are there questions for the panel? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. To the last gentleman that testified, so you can't get this job because you have a previous conviction.
Yes.
And if we allow you to expunge that conviction, then you'll be able to get the job. But since you know that the job wouldn't allow you to apply or to take the position, if you had that on your record, wouldn't that be a type of deception?
I'm not understanding. Explain that again.
Okay, if you expunge this off of your record,
right,
and you apply for the job,
yes,
the job will say, okay, you have no criminal record,
right.
But if you do that and you really did have a criminal record and you had it expunged, isn't that a form of deception?
I'm gonna tell the truth. So I'm not trying to deceive. I wouldn't try to.
You would say I don't have any record, right?
I mean, I would put down. I would tell the truth. I would say that I had a previous record, and if they want to fingerprint me and check, it's going to tell. It's going to show.
Not if it's expunged.
Irregardless, I'm still going to tell them.
Okay. Irregardless. And to the gentleman that said you had an answer to the gun question, so what's the answer?
Yeah, we were all sort of reconnoitering back there. Federal laws wouldn't let you have the gun because we can't change the federal laws in this room. Anywhere in this city, we can't change the federal laws.
So therefore, if a person had a record and they had their record expunged here in the state of Maryland and they applied to get a handgun, federally they'll be denied. Is that correct?
Yeah, that's correct.
There's no federal expungement whatsoever.
So therefore, if a person has a record, gets that expunged and applies for federal clearance, like at an airport or something like that, they would be denied because that record was still showed. They'd be flagged.
But that's a good exception. May I answer?
Yes.
Delegate. Okay, so
I mean, I'm seeing a head shaking back there, but
realize what it comes down to is how the federal law treats what happens in Maryland. Like right now, the federal law treats a probation before judgment as a conviction, right? So we're trying to change our law so that it's not. So the federal law for clearances might well say if an unexpunged conviction counts as a conviction and maybe an expungement, so that can change.
So is the answer to that question you don't know?
For right now, no.
Thank you very much.
It's how the federal law treats it. Yeah.
Thank you.
Yeah.
Delegate Kramer? No questions. Seeing no other questions for this panel, we thank you very much.
Thank
We're
you
going
all.
to go to those one person in opposition. John Cox.
On my own again.
Okay. 2 minutes.
I'm again John Cox, Deputy State's Attorney for Baltimore County, and speaking on behalf of the Maryland State's Attorneys Association, and ask for an unfavorable report as to House Bill 664. This bill, I testified, as I said, 9 days ago, when the proposal was to take the time limits down to 3 years and 5 years from where they are right now. This bill effectively just removes time limits at all. This says at any time. Now, I haven't been shown the amendments. I know that Senator Carter on the other in the cross file indicated. Thank you. Take up my 2 minutes. I know that there was some indication that it may have cleaned up the issue about how you could theoretically expunge something the day after your conviction and while you're still serving your sentence. So maybe that's been clarified or fixed. I'm not going to read it right now. But it still addresses the major concern that the State's Attorneys Association has, and that's the lack of knowledge for somebody who may have had a quite recent conviction if they were to do this again. And I mentioned last time looking at an option other than expungement, and that is to deal with all the other collateral consequences that have been raised in a way of a shielding of some nature, but not take away the knowledge from the criminal justice system, from the law enforcement agencies, from the judges, to know that, say, for example, 3 years ago, somebody committed the exact same offense. And here, we would be lost of all of that knowledge. We wouldn't have that anymore. I don't know, and with regard to Delegate Bartlett's one question about the chiefs and sheriffs, I haven't read their position, but the 3-year portion, I'm assuming, is about the statute of limitations for civil lawsuits or something of that nature. This doesn't fix that. This still allows for if a good cause determination is made, something inside of that 3 years. So that doesn't actually fix that particular portion of this. And I guess I'll stop there.
Are there questions for Mr. Cox? Delegate Bartlett, here she comes.
I didn't understand the last part, Mr. Cox. Yes, so the chiefs and sheriffs did say that they did make the comparison of 3-year civil liability. I mean, 3-year statute of limitations in a civil case. So what were you just saying? That you said it doesn't fix because why?
Well, the 3-year mention, and what I'm guessing again, although I haven't had a chance to read it, they put in the 3-year limitation on reapplying. I'm guessing that's what it was. Mm-hmm. It doesn't stop the first application at any time. And so, say, for example, somebody's convicted of an offense and their sentence was minimally short, let's say, a year probation. They could then apply for expungement right after that. So then we could be just a year and a little bit of time after the crime occurred. And then if the judge finds good cause, then it's expunged. And so then if that person turns around and sues the police department or sues somebody else, all that record is gone. That's what I assume the chiefs and sheriffs were expressing their concern about.
Okay, I read it to be that you can't start until the 3 years. Where's the?
No, I'm reading it right now. It just says, well, obviously we have the good cause portion already, which has no time limit on it. And then it says a person may file a petition for expungement on the basis of good cause once every 3 years for a felony and once every 5 years for a misdemeanor, which confuses me.
Yeah.
That
What's
must
the reverse? It's
probably
the reverse.
intended to be reversed, yes.
It's the reverse.
Okay. But that means you can apply right away. And so you could be inside the 3-year statute of limitations. And then if you're denied, then you got to wait another 3 years to try again.
Okay. I'll study. Thank you.
Delegate Phillips, then Conaway, then Cardin.
I do have to mention, as a kid growing up in Woodlawn, Sorrento's was really good.
I think I'll head there next.
So I just want to understand, and you're probably in a good place to share this with us. Is there any correlation between expungements and recidivism?
And that actually came up last time I was here. I have no way of knowing. Because if something's expunged, I don't know about it anymore. So nobody could do a study to say people who get expunged do or don't repeat offend.
I'm not sure about that, but okay.
Okay.
Chairman, thank you for coming in to testify today.
Certainly.
In the example that you gave where the person does the 1 year, I guess, probation and then applies to have their record expunged, what would be the good cause for that?
And that's a good question. That's totally up to a judge, and the judge just picks whatever the judge wants to be good cause. And it's not defined. I think that's another problem here. It bears interesting correlation to the other part of 10-110, where a judge is making, in these convictions, the judge is making a determination as to whether or not it's in the interest of justice, not a risk to safety or the success of rehabilitation. So I don't know how different it is from what's there already.
Okay, thank you very much.
Certainly.
At the end of the day here. First of all, when you file an expungement that precedes the 3 years now, don't you have to also file a waiver? Right, but there are expungements where you do have to file a waiver, right?
But there are expungements for non-conviction. Less than the 3 years. There we go. If that's less than the 3 years, then right now it requires you sign in a waiver.
Right.
Yes.
So why couldn't we just add waiver language in if you're doing it like on these convictions as well, to protect state's attorneys and police?
Well, if that were my only issue, then I'd say, great, let's go.
Okay. So that's,
But
that's a
that's
solvable
certainly one piece.
So, okay. In addition, if we found out that there was no correlation between people who got expunged and recidivism, would that change the opinion of the State Attorneys Association? In other words, if there was a reverse correlation, that people who were expunged clearly were people who were non-reoffenders versus other people who chose not to, would that change the opinion of the State Attorneys Association, you think?
I guess I'm going to play lawyer and find out what you mean by no correlation.
Or a reverse correlation, that the people that get expunged show a much reduced statistical significance of recidivism, much reduced.
Yeah, I still have concerns with the much part, I guess, to it.
Okay, I mean, let's say the recidivism is less than 10%. Let's just say, for example, would that maybe give you guys pause? Say, whoa, these are the good risk people that we should probably be allowing if the statistics showed that.
Probably.
Okay.
I mean, I doubt that's true, but
okay.
it certainly would have an affect.
But you're saying that you don't think we can find this information out? You don't think that we could put together a study that shows that the people who apply and we could find out who applies for expungements? I'm assuming that you guys get notice and you get to chime in on that. You keep records of that information.
No, we can't.
Well, you could keep records. You can't keep records of who they are, but you can keep records of the number of people that are expunged. Can you not?
But then how could I go back and look and see whether or not they're reoffended if I can't identify them?
I'm trying to figure out if there's a way to do it without identifying people.
I don't know how.
Yeah. Okay. All right. Thank you.
Delegate Valentine.
Yes, sir, and thanks again for coming in today.
Certainly.
And I have a question regarding the 3-year civil liability part that is in the Chiefs and Sheriff's letter, and I'm just going to give a hypothetical situation that may or may not be a real-life situation. So, under a scenario where you have a DUI arrest, for example, and you have that 1-year probation, okay, and a good cause is shown, and say an expungement is granted, and on the 2nd year, 11th month, 15th day, a civil suit would be filed against the arresting officer and any assisting officers for some part of that arrest. Would that expungement then eliminate the ability to reference that arrest, that paperwork, that all of that documentation in any type of a civil claim? I'm wondering if that's what they're referencing to.
Yeah, I don't profess to be
defend that.
Been doing all criminal law all my life, but I mean, it certainly would be difficult to defend. I guess the irony is one would assume that the plaintiff would have to have mentioned it if they're filing the suit, but I don't know.
That's what I'm wondering, if that's what they're getting at.
Maybe.
Thank you, Mr. Chair, for my second bite. Okay, so I just want to ask you one question. When, in your mind, do the 3 years begin?
Which 3 years?
The 3 years that we've been talking about for the past 10 minutes.
This is, if you're if we're talking about the amendment or the change here, which I just was handed, I read it, or the way it was explained by the delegate, and the way that I think I read this and trying to read through it quickly is the 3 years is when you can apply again. So you can apply once, anytime, and then if that's denied, then you have to wait 3 years to apply again.
Okay, that's just not, that's in no way what I see on the amendment, but the sponsor knows her amendment better than I do, but I read it to say that a person may file a petition for expungement on the basis of good cause once every 3 years.
Right, so they can do it, they do it once and then every 3 years.
No, that's not the way I read it. I'm just saying that's not the way I read it. Perhaps we can fix that amendment. You know, just say the way I read it, and the way after I talk to the sponsor to see how she wants it to read. But the way I read it, and I just want to ask you a question about it, is that a person may file a petition somewhere after 3 years, and then once every 3 years after that. The way I read it is that it starts at the 3 year period.
And respectfully, I read it differently.
Okay, we can agree to that.
Okay.
All right. But my point is that if it did say that, you'd still be opposed because you'd be losing the information that you said law enforcement needs.
Yes, and it would effectively become, I think, your bill.
No, not quite.
Okay.
I'm not quite that far out. But, okay, let me ask you another question. When you state that, and I do understand what you're saying about law enforcement needing to know prior history, right? But when I go, let's say I move back to North Carolina, will law enforcement know in North Carolina what I did in Maryland?
If something's not expunged? Or,
Right.
Yes,
Something is not
they can if they go to the work.
Right, and so how many steps do they have to go through to find out what I did in Maryland if I go to North Carolina?
Well, I mean, the standard way, and things have changed when we've gotten to so many cases being charged by summons, but the standard way any law enforcement agency would look at for somebody's record is to go to NCIC, and then they get responses from any state that has a record on a particular individual. Mm-hmm. And so then Maryland would respond to their NCIC check, and then they'd see that. There's a little bit of a glitch nowadays because if things are charged by summons, they sometimes don't get into the CJIS system. But that's the way that they would first find out. And then presumably they would, if they want more details, they would contact whatever law enforcement agency had the case.
So now we're getting to where I really wanted to go, Mr. Chair, for 1 second. So with that glitch, do you have any indication that because of that glitch and because they don't know about those, that there has been a problem or hindrance to law enforcement in doing what they need to do? I don't have your exact words here. What I'm getting at is that your premise is because we can't see, we won't have all the information, and therefore we're going to be hindered. Law enforcement would be hindered. My question is, if there is a glitch where there are some times where law enforcement can't see, do you have any indication that law enforcement has been hindered?
I don't know. I mean, in all honesty, I just mentioned that glitch because I was referencing NCIC and CJIS. We all know that if a conviction exists, even if it was charged by a summons, it's in case search.
Let me put it this way, if I may. Do you have any indication that where law enforcement doesn't have information of prior convicted crimes or convicted crimes in which a person has served their sentence, do you have any indication that the lack of that knowledge has somewhat hindered state's attorneys or other members of law enforcement in doing their job or getting their convictions or doing whatever they need to do.
Well, I know that it would, if we're talking
But
about.
how do you know? That's my
Okay.
question, I guess.
If we're talking about cases that are expunged, I think even with Delegate Cardin's hypothetical of only 10% reoffend, 10% of the time, then I'm not going to know about that person's prior offense.
I guess what I'm getting at is your knowing needed in cases, and if it is needed, can you tell me how it's needed? What I'm getting at is, if you don't know, I need for you to tell me that if I don't know, I won't be able to do X, Y, Z, then I need to know circumstances in which you didn't know and you weren't able to do X, Y, Z. That's what I'm getting at.
Okay.
So that's my question. And if you don't have that data, that's fine. But I just, it's always helpful if I have something to, to look at and to understand as to, well, in all these cases where there had been expunged situations, where it's been expunged charges, look at all these folks who reoffended, and we weren't able to get a conviction on them because we didn't know about all these other, all this expungement or something. That would help me. But you simply telling me that it's going to hurt or impede your ability to do, to get convictions is just simply not enough.
Well, and I understand. And as I addressed earlier, I mean, I cannot give you examples of cases where I've had somebody in court and I couldn't tell about their prior expunged conviction because I don't know about it.
That's my point, though.
Well, but the point that I was trying to say is that an individual addressing whether or not they should be expunged in the first place. So if I have somebody in court and it doesn't get to getting a conviction, it gets to what the just sentence is. So if somebody, commits a theft, and then they get it expunged, and then they commit another theft, and then they get that expunged, and then they do it again, and they get that expunged, and then they commit another theft, and I walk that person into a courtroom and am successful in getting them convicted. I'm not going to bring in their priors, even if I knew about them. I can't tell the judge, this person's done this 3 times before. That's my point. The ability to face justice for what you've done in the past, I think, or what you're doing now, what you've done in the past ought to be relevant to a judge's determination as to what an appropriate sentence is. If a judge thinks every time they see somebody, this is the first time they've done it, then nothing really in terms of punishment is going to happen. And then it goes away again, and then the pattern continues. All I'm asking for, or 2 things I'm asking for, is a longer time period before that can happen. And second, affect whether or not the justice system can still have this, whether or not I can still tell a judge about it, and contrast that with every other use that could be used. And that's what I was talking about with shielding. To take it away from people who are doing background checks for employment purposes, or all the other collateral consequences that have been mentioned, but don't take it away from the criminal justice system so that individuals can answer for what they've done when they do it again.
May I ask one more last question? I promise. I promise. Okay. So, in Maryland, prior bad acts, admissible, not admissible?
It depends.
Exactly.
Right.
Exactly. And so that, in that regard, because it depends, I feel that that's the correlation I make with expungement based on what you were just saying. We have decided that there are some times where we don't need to know, or the jury doesn't need to know. All right? And so I make that comparison when it comes to expungement. If a person has done their time and they are now, or they have good cause, and they're now saying, expunge my record, I believe that there are times where we don't need to know and justice could still be served. Isn't that so? And you can't really answer that.
Oh, darn.
Unless you want to. Unless you want to.
I would love to. I mean, just real quick, the getting the conviction is not the important thing. And so I could live without not knowing about whether they've done 3 thefts before if I'm trying to prove that they did this theft. And most of the time, I couldn't do it even if I wanted to. My key is the sentencing part.
Was it fun? Great. Seeing no further questions, that concludes the testimony on House Bill 664. And that concludes the testimony for all the bills today. We will have a voting session tomorrow immediately after session. Immediately after session. Thank you very much.
But now that's.
I don't want to necessarily go there.